cameras on their cell phones off, we'd appreciate that. If everybody would stand, we'll say the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we're 5:30. We're at 1500 Highway 2, Sandpoint, Idaho. We're in the third floor conference room. This is the Planning Commission's second meeting of the month. Roll call from my left, please.
Oh, that's, Debbie Trinan.
Alan Songstad.
Commissioner Pilch.
Commissioner Davis.
Commissioner Frankenbach.
Commissioner Benner. Commissioner Bailey as chair. We have a full quorum. Any changes in the agenda? I was not present at the May 3rd meeting. Did everybody have a chance to look at the minutes? Any changes?
Yes, I'll move approval.
Approved. Okay, anybody in the audience need hearing or speaking aids? Everybody can hear okay? Everybody needs to speak into the microphone. The audio, we're being taped. Obviously, we're live Zoom and YouTube. Okay, it's 5:32. Our first file is AM 0005-22 comprehensive land use plan map amendment. Manford. The applicants are requesting a comprehensive land use plan map amendment from rural residential to resort community. The property is zoned Rule 5 acre. Project is located off Gulf Estates Drive in Section 24, Township 60 North, Range 5 West, Boise Meridian. Are there any conflicts of interest? Hearing none, Chad, you can present the file, please.
Thank you, commissioners, for being here tonight and members of the public. We appreciate your participation. We're here tonight for a comprehensive land use plan and map amendment request for a property located in Section 24, Township 60 North, Range 5 West, Boise Meridian. The request is to amend the comprehensive land use plan. I apologize, they're on screen here. For a property, it's a 1.25 acre property. It's currently in the rural residential comprehensive land use plan designation. They're requesting that it's changed to resort community. Unplotted property, accessed by Gulf Estates Drive. Sorry, there's a typo there, which is privately owned and maintained. There's sewage on site from the Kalispell Water and Sewer District. There's currently an individual well on the property. It's afforded fire protection by the West Priest Lake Fire District. It's powered by Northern Lights, and it's in the West Bonner School District. And there are no map streams, either intermittent or perennial on the property, as well as wetlands. There was just a little bit of map slope on the property in the southwest corner, between 15 to 29% grade. Largely speaking, though, the property is unremarkable in terms of slope. Soils on site are kind of a primarily not prime farmland, and between drainage classes of well drained and moderately well drained. These are the standards we use to review the file, as well as looking at the goals and objectives of the comprehensive land use plan. We routed the file for comment to the agencies on screen here. We did get some comments back. Idaho Department of Water Resources commented said they take no position on this proposal, but recognizes that some activities will fall within this jurisdiction. And basically, if they're to construct a new well on the property, they would have to be consistent with the state statutes for that and contact IDWR. Panhandle Health also looked at the application and commented. They said that, they acknowledged that the applicant identified that they're connected to the Kalispell Bay Water and Sewer District. And essentially, we're requesting the applicant to speak with that sewer district to make sure that there's feasibility. Particularly in this case with this application, they indicated part of the reason for this request is to eventually divide the property into 2 equal over half-acre properties. Fish and Game said they don't have any comments to submit for this application. Didn't identify any critical wildlife habitat on the property. And we got a pretty generic response from Idaho Department of Environmental Quality saying that they don't review projects on a project-specific basis and provided general comments as they typically do. I do want to note that, a lot of these are just, this isn't the entire letters. So please see the letter for full details for these comments. All their agencies didn't respond. I checked the file before coming up here tonight. As of today, 5:20 p.m., no public comments in writing for this application. So the current comprehensive land use plan designation of rural residential provides for residential development in areas where urban services are not available and slopes may vary up to 30%. These include hazard areas and critical wildlife habitats where low densities reduce potential impacts to resources and exposures to loss of property or lives. Small-scale agricultural uses and residential development are permitted. And so the applicant is requesting to change this designation to resort community, which provides for urban-like densities for areas centered around recreational areas developed for winter and water sports, golf, hiking, and where urban services are provided. And I just kind of highlighted a couple of things here because I think it speaks to the property and what it's surrounded by, and also the fact that it's in a water and sewer taxing district. And so, and I could pull up the map too if you'd like to look at that in more detail, but it is a budding property that's in the rec zoning district as well as resort community. So this project was also reviewed against the goals and objectives of the comprehensive land use plan. The details are in the staff report. And as a result of that, looking at all those goals and objectives, looking at the character of the land, where it's situated, what it's around, the fact that it's in a water and sewer district, staff did find this proposal consistent with the Bonner County Code and the Bonner County Comprehensive Land Use Plan, and is thus recommending approval today for the Planning Commission. At this time, I can take any questions.
Questions for staff?
Chad, can you
Yes.
pull up the map and,
Yes.
and let's look at the.
I currently have the water and sewer district layer on, so you can see that's within that. Was there a specific layer you'd like to see?
Just the zoning. Also, okay.
It does appear to be split zone, but I think the map is off a bit here, because if you look at the pattern of where this parcel's drawn here, this is the property here, land use.
I thought I read in the staff report that it was split zone.
Yeah, it was a little difficult to ascertain, and that's why I included that in the staff report. If you look at where these parcel lines fall, though, and where this was drawn, it does look like there was a bit of a mapping error. And we're up here, sorry, this property right here.
Did you maybe you pulled it up, the topography slope?
Yep. So, and this is just this tiny piece right here. It's 15 to 29% grade.
You said it's in the sewer district.
That's correct.
That's all I've got.
Any other questions? Yeah. Is there a representative for this file here?
don't believe so.
Hey, so sir, if you'd like to come up, if you're part of the
Oh, yeah.
application, then come up and
Apologies. Oh,
name and address for the record.
yeah. Hi, I'm Jacob Manfred. I live at 111 Gulf Estates. So, yeah. And this is just my family's property. We're just looking to eventually build it with the other family that lives there in the trailer next door. So that's pretty much all we got going on. Thanks. Is that?
Right.
Yeah. Thank you.
Any questions of the applicant? Thanks, Jeff.
Thanks.
All right, so anybody in the audience wish to comment on this slide? Comment? Anybody online? Okay, so we'll close public comment. We'll move to commissioners.
Mr. Chairman, I seems to me that it's a reasonable request. It's right next to the recreation property. Obviously, has some attachment to the golf course, although it's not on the golf course. So at the appropriate time, I'd move approval.
So go ahead and make your motion.
I'll move to recommend the approval to the Board of County Commissioners for this project, file AM 0005-22, requesting a comprehensive land use plan map amendment from rural to resident resort community, finding that it is in accord with the general and specific objectives of the Bonner County Comprehensive Plan and the Bonner County Revised Code as enumerated in the following conclusions of law, and based upon the evidence submitted up to the time of the staff report was prepared and the testimony received at this hearing. Further move to adopt the findings of fact and conclusions of law set forth in the staff report and direct standing planning staff to direct written findings and conclusions to reflect this motion, have the chairman sign and transmit to all interested parties. The action does not result in the taking of private property.
Commissioner Songset has made a motion to approve file AM 0005-22, comprehensive land use plan map amendment, Manford. Is there a second?
Simon?
Go ahead. Ladies first.
Oh. Ooh, Trinan second.
Commissioner Hyman with the second. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. Our next file is AM 0004-22. Text amendment to BCRC 12-341 general provisions for non-conforming use and structures. The applicants are requesting a text amendment to BCRC 12-341, proposing a provision for accumulated expansion by up to 10% of the commercial, industrial, or public use set forth in BCR 12-333, Table 3-3, BCRC 12-334, and Table 34, BCRC 12-335, for structures in any zoning district that were established prior to November 18, 2008. The applicants are also requesting that the natural material resource-based uses operation under an approved Idaho Department of Lands Reclamation Plan set forth in BCRC 12336, Table 36, non-conforming uses existing on November 11, 2008, be approved to have the provision to expand within the parcel boundaries. conflict of interest on the board?
Mr. Chair,
Yes,
Commissioner
sir.
Benner, I have some conflicts from past with the Planning Commission and County Commissioner days, so I think I should excuse myself.
Mr. Brenner's going to excuse himself. I have a covey of conflicts with two different companies, so I'm going to excuse myself also. So Alan will be taking the gravel.
Okay,
Okay.
I think we're ready for a staff report.
Good evening, commissioners and members of the public. We are here for the text amendment requested for BCRC 12-341, general provisions for non-conforming uses and structures. I'm Swati from Planning Department. These are the applicable codes from Idaho State Code and Bonner County Revised Code. We noticed this filed to several public agencies on March 24, 2022. Of those that replied, Bonner County Road and Bridge, Idaho Department of Lands and Ocean Water Association were the only ones who replied with comments. Clark Fork Valley Fire, Independent Highway District, Kootenai Indian Tribe, Pondere Hospital District were the ones that replied with no comments. And we did not receive any other comments from other agencies. We did receive 5 public comments that were received during the comment period, and 3 were received after the comment period closed. All have been included as part of your file. This is the current code that has been proposed for amendment. And here is the proposed amendment. The letters that are in red and underlined are the proposed language. The one that are in black and have strike through them is the language that has been proposed to be removed. So the code reads like this: general provisions for non-conforming uses and structures. Subject to the provisions of this subchapter, a non-conforming use or structure may be continued, but may not be extended or altered unless necessary to comply with a lawful requirement and unless the use or the structure is a less intensive use than the permitted uses in the zone, such as a residence in a non-conforming residential zone which has been rezoned to industrial. The changes have been proposed to the exceptions to this code. The accumulated expansion by up to 10% of a commercial, industrial, or public use set forth in BCRC 12-333 and Table 33, 12-334 and Table 34, 12-335 and Table 35, or structure in any zoning district that was established prior to November 18, 2008, and that has been in use continuously since November 18, 2008. Is permitted, provided no additional land areas being acquired for the expansion. No changes have been proposed to point 2. The applicant is also recommending addition of point 3 to specifically address resource-based uses. For natural material resource-based uses operating under an approved Idaho Department of Lands Reclamation Plan and set forth in BCRC 12-336 and Table 36. Non-conforming uses may be expanded within the parcel boundaries existing at or on November 18, 2008. For the complete development of the material resources of the state or any other necessary means to their complete development, or any other use necessary to the complete development of the material resources of the state. Staff analysis will go through each of these amendments one by one, along with the staff recommendation. So the first proposed amendment is to clarify which uses we are talking about when we talk about commercial, industrial, or public uses. The intent here is to add clarity to the code. In the past, it has been this part of the code has been misconstrued to include resource-based uses as well. So, so the intent here is to add that clarity by adding set forth in BCRC 12-333, table 33, and so on. These specifically refer to the commercial uses, public uses, and industrial uses that have been defined in the code. However, this modification does exclude uses that could be new or unanticipated, that are not directly listed in these tables, but may be approved through the provisions of BCRC 12-331 or 339. And therefore, staff recommends that those should be included in the proposed text. The second amendment is to request for the change of date from December 9, 1981 to November 18, 2008. So on November 18, 2008, Bonner County repealed the existing Title 12 at the time in its entirety and replaced it with a new Title 12 of Bonner County Revised Code through Ordinance number 501. Consequently, several commercial, industrial, and public uses that were permitted between 1981 and 2008 became legal non-conforming. Currently, the provisions of subchapter 3.4 allow for lawful expansion of legal non-conforming commercial, industrial, and public uses that were established before December 9, 1981 only. So this amendment would afford the same lawful expansion rights to the uses that were permitted between 1981 and 2008. This is the third point that was added to the text amendment for natural material resource-based uses, specifically mining, gravel pits, and other resources that require natural expansion for functioning and extraction of material from earth. So as we established earlier that the previous 2 points do not address resource-based uses because they have already been defined in subchapter 3.3. So this point was added to address resource-based uses that have been defined in that subchapter. While the proposed text here makes a reference to BCRC 12-336 and table 36, the focus of the amendment is only on a few of those resource-based uses that are listed in BCRC 12-336 or table 36. Those that typically require extraction of material from earth and natural expansion for continued functioning, such as mining, stone quarries, gravel pits, or those that may require an Idaho Department of Lands approved reclamation plan. Therefore, the amendment as proposed is not applicable to all uses that are listed in 12-336 and 36. For instance, agricultural direct marketing or confined animal feeding operations for farms. These are all resource-based uses that do not require ideal reclamation plans and should not be included with this text amendment. This amendment proposes expansion that may only be permitted within Idaho Department of Lands reclamation plan. The intent here is to address potential impacts of such an expansion to public health, safety, and welfare. While some of these impacts could be mitigated through reclamation plans, it is possible that the reclamation plans alone do not address all the public health concerns. The letter received from Idaho Department of Lands clarifies that in more detail. The agency notes that not all reclamation plans are reviewed by Idaho Department of Environmental Quality, Idaho Department of Fish and Game, and Idaho Department of Water Resources. The interagency review of the reclamation plans may only be required if potential impacts to water quality and wildlife are identified. The agency further states that the purpose of these interagency reviews is to identify if permits are also required from other agencies. These reviews, however, are not intended to address all the concerns raised by other agencies through reclamation plans, especially when the concerns lie outside of IDL's authority, such as noise, hours of operation, public safety, air quality, etc. Therefore, an approved reclamation plan is not sufficient and unlikely to address all relevant public health and safety concerns, even if the reclamation plan was approved after an interagency review. Some concerns can only be addressed through a review of the proposed expansion at the local jurisdiction level through a planning process such as a conditional use permit. Therefore, staff recommends subjecting the expansion to conditional use permit process and standards of BCRC 12-482 standards for specific uses mining. Additionally, if the expansions were to be subjected to a conditional use permit process, the language operating under an approved Idaho Department of Lands Reclamation Plan would become redundant because it is one of the requirements for the conditional use permit process of mining operations. Mining stone quarries or gravel pits are not permitted by right in any zoning district as per current Bonner County revised code. These uses are only permitted through a conditional use permit process in forestry, agricultural forestry, rural residential, recreation, industrial, and alpine village zoning districts. This leads to the understanding that the potential impact of such uses always requires some additional review through conditional use permit process. Hence, the expansion of such legal non-conforming uses should at least be afforded the same level of review process. The amendment further proposes that non-conforming uses may be expanded within the parcel boundaries existing at or on November 18, 2008. It is to be noted that if the text amendment were to be approved, the expansion of the legal non-conforming mining activities would be allowed to expand only within the parcel boundaries as they existed on November 18, 2008. Any increases in the parcel sizes since after November 18, 2008 would still restrict the expansion to the original parcel boundaries. In case of any reduced parcel sizes, the expansion of non-conforming use should be restricted within the parcel boundaries as they exist on the date of the request for expansion. This section of the code should not be used as an excuse for expanding existing parcel boundaries back to their original configuration in 2008. The second sentence in the proposed text, for the complete development of the material resources of the state or any other necessary means to their complete development, or any other use necessary to the complete development of the material resources of the state, seems to be a statement specifying the intent for requesting amendment. It, however, is not required to add any clarity to the sections of the code or the sentences preceding it. So staff recommends removal of this sentence from this section of the code. Staff will now go into the analysis of the complete amendment as a whole. The implementation of the proposed text amendment would require an assessment of the limit of legal non-conformity of the mining operations requesting expansion. The baseline shall be established by the latest Idaho Department of Lands approved reclamation plan till the time the use remained legal. This has been explained in more detail in the staff report. However, that is only a likely implementation of the proposed amendment. It is not one of the recommendations as to how the proposed amendment should be implemented. This requested text amendment meets several objectives of the comprehensive plan. If approved with staff recommendations based on the following key points and those listed in the staff report. This amendment is proposed with the limitation that the legal non-conforming resource-based uses be allowed to expand only within Idaho Department of Lands Reclamation Plan. Staff also recommends that the expansion be allowed through a conditional use permit process in order to bridge any gaps for concerns related to public health and safety. Developments in Bonner County require provision of services such as roads as applicable to each development per Bonner County Revised Code. Land use facilities such as gravel pits facilitate construction of new roads and upgrading of existing ones. As noted in the comments received from Bonner County Road and Bridge Department, the agency is in support of the proposed text amendment as the gravel pits owned by the county are used for mining materials needed for the construction and maintenance of public roadway system. The proposed amendment to the land use code acknowledges the value of water and wildlife resources. This text amendment is proposed with the limitation that the legal non-conforming uses be allowed to expand only within ideal approved reclamation plan to address any concerns related to natural resources such as water quality, wildlife, etc. This proposed text amendment would facilitate construction of roads and access within new developments for provision of fire and emergency vehicles and routes of escape by allowing procurement of materials from continued functioning of legal non-conforming mining gravel pit resource-based uses. This is the text amendment that was proposed. And then we'll go into staff recommendation. So all the text that is blue and underlined are the changes that have been proposed by staff. The ones that are in black and have strike through them are the ones that are proposed to be deleted from the code. The accumulated expansion by up to 10% of a commercial, industrial, or public use as set forth in BCRC 12-333 and Table 3.3, BCRC 12-334 and Table 3.4, BCRC 12-335 and Table 3.5, or other uses that may fall within the same categories through the provisions of BCRC 12-331 and BCRC 339. Or structure in any zoning district that was established prior to November 18, 2008, and has been in use continuously since November 18, 2008, is permitted, provided no additional land area is being acquired for the expansion. No changes have been proposed to point 2. The expansion of resource-based uses such as mining, stone quarries, gravel pits, uses typically requiring material extraction from earth and natural expansion for continued functioning, as set forth in BCRC 12-336 and Table 3.6, or other similarly resource-based uses that may fall within the same category of uses through the provisions of BCRC 12-331 and BCRC 12-339. Established prior to November 18, 2008, is conditionally permitted within the parcel boundaries as they existed on November 18, 2008. It has a subpart to this, which talks about the reduced parcel boundaries. In cases where the parcel sizes are reduced since after November 18, 2008, the expansion of the legal non-conforming use shall be restricted to the parcel boundaries as they exist on the date of the request for expansion. These recommendations are based on these following findings of facts. Citizens of Bonner County per Idaho Code Chapter 65, Title 67 may recommend a zoning ordinance. The Bonner County Planning Department has reviewed the proposed changes against existing code and the comprehensive plan, and laid out the reasoning for the staff report in this staff report. The applicants are requesting amendments to BCRC 12-341, general provisions for non-conforming uses and structures. The intent of the text amendment is to bring clarity to the provisions of the code for commercial uses, industrial uses, public uses, and resource-based uses. The amendment to BCRC 12-341A1 excludes uses not directly listed in the above reference tables, but are either permitted by right or conditionally in compliance with BCRC 12-331 or 339 that provide for new unanticipated types of land uses not directly listed in BCRC use tables. On November 18, 2008, Bonner County repealed the existing Title 12 at the time in its entirety and replaced it with the new Title 12 regulations of Bonner County Revised Code through Ordinance number 501. Consequently, several commercial, industrial, and public uses permitted between December 9, 1981 and November 18, 2008 may now be legal non-conforming. The proposed text amendment addresses certain resource-based legal non-conforming uses such as mining, stone quarries, and gravel pits. Uses typically requiring extraction of material from earth and natural expansion for continued functioning through addition of BCRC 12-341A3 to allow expansion of such uses within parcel boundaries within Idaho Department of Lands approved Reclamation Plan. As per the comments received from IDL, the agency notes that an interagency review with DEQ, Fish and Game, and IDWR may not be required for all reclamation plans unless potential impacts to water quality and wildlife are identified. Interagency reviews are undertaken to identify if permits would also be required from other agencies, suggesting improvements to mitigate impacts to water quality and wildlife. The agency further notes that interagency reviews are not intended to address every concern put forward by the other agencies, especially if those issues lie outside of IDL's authority, such as noise, hours of operation, public safety, air quality. The second sentence in the proposed text, for the complete development of the material resources of the state and so on, it seems to be a statement specifying the intent for requesting this amendment. It does not add any clarity to the current code or the proposed amendment. This amendment proposes expansion of legal non-conforming mining activities that would be allowed to expand only within the parcel boundaries as they existed on November 18, 2008. In case of any reduced parcel sizes, the expansion of non-conforming use should be restricted within the parcel boundaries as they exist on the date of the request for expansion. The proposed amendment is in accord with the general and specific objectives of the Bonner County Comprehensive Plan. The Board of County Commissioners is authorized by Idaho Code Chapter 7, Title 31 to adopt ordinances, rules, and regulations not repugnant to law, necessary for carrying into effect or discharging the powers and duties conferred by the laws of the state of Idaho, and such as are necessary or proper to provide for the safety, promote the health and prosperity, improve the morals, peace and good order, comfort and convenience of the county and the inhabitants thereof, and for the protection of property therein. Based upon the reasoning provided in the staff report, the findings of fact and conclusions of law, the proposed ordinance improves and adds clarity in the interpretation of Bonner County Revised Code. Based upon the reasoning provided in the staff report, adopting the proposed changes will further balance the provision of safety, health, and prosperity while maintaining the protection of property, peace, good order, comfort, and convenience of the county and its inhabitants. These are the conclusions of law. The proposed amendment is in accord with Idaho Code Title 31, Chapter 7. It is in accord with Idaho Code Title 67, Chapter 65, and it is in accord with the general and specific objectives of the comprehensive plan. And I can take any questions at this time.
Any questions of staff? I have one question. Are the findings of fact and the conclusions of law that you've just gone through, are they reflective of staff recommendations?
They are reflective of staff recommendations.
Any other questions of staff? All right, we'll move to the applicant. State your name for the record, please. And address. That will go for all public testimony.
Beautiful. Thank you, commissioners. My name is Jeremy Grimm, owner of Whiskey Rock Planning Consulting, professional planner in Bonner County, planning director for the city of Sandpoint from 2007 to 2015. Here representing a variety of interested parties tonight. I'll be providing a presentation to hopefully add some clarity to what was presented in the staff report. That'll be followed up by Toby McLaughlin, who will be putting a bookend on what I'm presenting here. I want to just emphasize a couple things before I start. One is that the applicants are not interested in staff's recommendation and amendments to our request and our application. We are respectfully requesting that you act on the code amendment as is highlighted here that was included in our application. So this is really about housekeeping. That's effectively what we're doing here. Throughout time, things have gotten a little convoluted or confused. So we want to try to help clarify that. So why is this amendment being proposed? First of all, existing code is insufficiently clear. There's a variety of misinterpretations of code that threaten the continual provision of essential materials, which all residents and businesses and elements of government require. Misinterpretation of the code jeopardizes the investment-backed expectation of landowners and businesses. It threatens over 400 direct and indirect jobs in Bonner County. The Planning Commission continually faces confusing arguments and conflict. And this amendment, as proposed in our application, will bring certainty and resolve conflict by establishing express standards as required by Idaho Code 676535. So I'm going to discuss mining, uses, employment, and location. I'm going to talk about the Bonner County Comprehensive Plan and policies. I'm going to try not to get too deep into the Idaho Constitution, but it's important that you understand where this authority lies. I'm going to talk about some characteristics of use, agency and environmental review, and finally, I'm going to rebut Mr. Allen from Gibbons Pursley, his issues that he raised. I really want to emphasize the folks who I'm representing do not oppose requiring a conditional use permit for new mining on new parcels. That is very clear, and just want to get that out there. That is not a concern of ours. So first, to talk about the aggregate industry, you have to mine where the material is, not where it can be conveniently zoned. This was straight from the deliberations of the Planning and Zoning Commission back in 2007. I also want to emphasize this isn't about the Linscotts. It's not about a single mine or a single location. The decision that you make and the Board of County Commissioners will make will impact dozens and dozens of gravel mines and mines that are essential in Bonner County. And this is an illustration of the location of those mines per the comprehensive plan. Aggregate is an essential element for all modern life. If you live on a driveway, if you have a house, if you have a septic system, and if you drive on a county road, you are using this essential product. It is utilized everywhere. And as an essential product, it's essential that we have access to it. It's commonplace for residential and commercial development and activity to grow up around mines. Many of you have been to Coeur d'Alene. This is just west of 95. A large aggregate mine right in the heart of Coeur d'Alene, surrounded by commercial and residential. There's another one right down the street, right next to the Croc Center, again, surrounded by parks, residential and other activity. In Post Falls, this is a bit of a dated photo. If you went there today, you'd see a bunch of subdivisions adjacent to this aggregate mine. In Spokane, this is out by the mall, northern Spokane, a large aggregate mine, and Spokane Valley. My point in showing you these is that aggregate historically is utilized and mined where it lies, and it's an essential element, and communities grow up around these mines. I also want to point out that one of the concerns we have with the staff recommendation suggesting that a conditional use permit would need to be issued for this continuing operation is that the aggregate is demanded at different times of the day, depending on a state contract. Sometimes you have to pull mining material out in the middle of the night. So it does not lend itself well to conditional use permits. In fact, I'm not sure how you could draft one that would really suit the need of the state. Moving to some guiding policies in the comprehensive plan and Bonner County Revised Code. So this is our recommended language. And I just want to emphasize the prerequisite is that there is an approved IDL plan. We are not suggesting that mining can occur anywhere in the county. So Bonner County has adopted a natural resource policy, and I just want to highlight a few of the elements of that natural resource policy. A major goal of Bonner County is to show support and create finished products from natural resources extracted within the boundaries of the county. It's the goal of the county to encourage and enhance natural resource industries. Goal 7.1, to promote economic environment that will result in increased local economic benefit from resources contained on private and public lands. 8.5, for no net loss of investment-backed expectation on private land. Under goal 9, the county must strive to protect its mining heritage, to protect the vital natural resources that are necessary to keep these enterprises in operation. 9.5, under commercial mining, they provide significant economic value. And finally, under 26.1, the county recognizes that the full development of its abundant mineral resources is desirable and necessary. This is pretty strong. It is the position of Bonner County, and as a de facto, you represent Bonner County. I also love that the county has adopted this and put it on their website, the Code of the West. I assume everyone's read it who's moved to town or lives here. Starting under 3.0, there are many issues that can affect your property. It's important to research them before purchasing land in a rural area of the county. It goes on. Owners of mineral rights have the ability to change the surface characteristics in order to extract these minerals. Be aware that adjacent mining uses and gravel pits can expand. Make an educated and informed decision before purchasing a parcel of land out in the country. Looking at the comprehensive plan, there's not a lot to pull from here, but I did want to talk about this element because I know there's some concern about how many of these mines are going to be out there operating under their original parcel boundaries. About 10 to 15% of the mining operations in the county do not have an approved reclamation plan. I want to emphasize that I'm personally aware of some of these that are operating that are owned by elements of government, whether it's the city of Sandpoint, Clark Fork, Bonner County, or others. My point here is there are not huge numbers of mines that are not operating without a plan prior to 2008. So jumping to the state constitution, this gets a little heady. Putting it in here for the record if this ends up someplace we all hope it doesn't, which would be court. Section 14 under the Declaration of Rights, Article 1, talks about eminent domain. It if you're not aware, eminent domain is when the government can come and forcibly take your land because there's some perceived public benefit. Well, in Idaho, if you're not aware, it goes far beyond that. And it allows eminent domain for the necessary use of lands for the complete development of the material resources of the state. Beyond that, this case, Boise Redevelopment versus Yik Kong Corp., we state that it notes that the Constitution of the State of Idaho, Article 1, Section 14, grants a right of eminent domain broader than it grants in most other states. For example, complete private interest in the irrigation and mining businesses can utilize eminent domain. I mean, think of lithium, think of essential minerals that are needed for batteries, uranium, World War II. There is a compelling interest. These minerals are essential for the public good. Going on to the Idaho Constitution under that same provision, it talks about the right of eminent domain is permitted in theory of a public use for the complete development of the material resources of the state, even where the public may have no direct interest in the exercise of the right of eminent domain, meaning like it doesn't benefit you, John. I'm sorry, we're mining lithium under your property or uranium, and we're of course not talking about that here, but it's important to emphasize and understand how important mineral resources are to the public. Clark and Nash go on, as the irrigation and mining, this confers the right to condemn for individual use on the theory that the development of individual property tends to the complete development of the entire state. Looking at Bonner County Revised Code 12340, this is really the crux of the housekeeping here. So you're all very familiar with it, I'm sure. If not, you are now. It talks about, uses in a zone. And it talks about characteristics of uses which were lawful before the title was passed or amended, 2008. It is the intent of this title to permit these nonconformities to continue. The mining is a nonconformity in some zones. It's further the intent of this title that nonconformity shall not be enlarged upon, adding other uses. So we're not adding new uses in an existing gravel mine or a mine. It's the same use that was non-conforming from the start. When you look at American Jurisprudence, which is an encyclopedia of United States law, it talks about this general rule that a non-conforming use may not be extended to land not so used prior to the enactment of the restrictive zoning ordinance. But it talks about this being a hardship where the use in question involves the removal of natural products from the earth. For example, quarries are particularly vulnerable because their very nature and characteristic, they begin on one spot and spread to additional ground as the mineral reserve is exhausted. Such diminishing asset enterprises use all the land contained in a particular asset. So the courts therefore have respected the unique character of such diminishing asset uses by allowing expansion. So when we look at, again, back to Bonner County Revised Code 12341, in more detail with the subchapters here, it says subject to the provision of the subchapter, a non-conforming use may be continued. But there's this exception, and this is what we're trying to clarify. The exception is the accumulated expansion by up to 10%, but it's specific to commercial, industrial, or public uses or structures. It does not reference what we are focused on here is the natural resource table and the natural resource uses. Not commercial, not industrial, not public, natural resource uses. And here is that natural resource table. So you can see here, natural resource table 3.6, 12336, resource-based table, mining, stone quarries, gravel pits, stone mills, etc. Okay, mining is not a commercial, industrial, or public use as identified in Bonner County Revised Code. Therefore, we need clarification because it's not applicable to limit or even suggest the expansion should be limited to 10%. So I wanted to show you a couple of illustrative examples. I'm a visual person. So imagine this is farmer. I'm going to use farming as an example. Farmer Jane. Okay, Farmer Jane, year one. Let's say it's October 2008, before the big code amendment came through and everything became non-conforming. So she's zoned ag forest, farm agriculture use. She's got 5, 10, 15, 20, 25 sheep and a couple beefalo on 40 acres. You can see in the resource-based use table, this is all permitted. Life's good for Farmer Jane. One day after, we'll call it November 19th, 2008, it's rezoned to suburban. Uh-oh. Well, it's okay. She's legally non-conforming. You can see in the bottom left here, now under the suburban zone, agriculture is going to be restricted with all these subnotes, 11, 12, and 13. I've got 13 up here. So animals are limited. Total animals shall not exceed 20, no matter the acreage. Feeding areas have to be no closer than 40 feet. Beefalo are prohibited. So Farmer Jane's got a problem. Let's go that next day, say all those animals were pregnant. Well, now Farmer Jane's vastly exceeding the new non-conforming expansion, potentially, if you interpreted it like that. She's got a bunch more beefalo. She is in violation. Oh my gosh, she's expanded her use by more than 10%. No, she is non-conforming because of the use of the property as a farm. And if you follow this to its logical conclusion, non-conforming structures, really simple, 10% expansion. You can define the footprint. It's a 1,000 square foot building. It's allowed to go to 1,100. The assessor office would have data on this. There's easy applicable evidence that you could use to show the expansion of a structure. But use, how is use determined? Are you going to use some arbitrary standard? The number of animals, the area of the manure pile, acreage of the grazing area, the footprint, the employees, the trucks, the equipment she has, the type of animals she has. Furthermore, who would have any of this information from the date she became non-conforming? Not Bonner County. Did you get a letter the day after the zoning, went into effect, November 19th, that defined the limits of what she could do under the non-conformity? Has she been notified that she's expanded her use? She now has, 3 beefalo. An operating established farm was the legal non-conforming use. It's the use that's grandfathered. Changing or mixing animal types, goats, pigs, reacting to market demand. This is what a farmer does. Her use is changing, but it's the use that is grandfathered. What if it was a slow year, the year that she became non-conforming? And, in the years past, she had lots of beefalo. You can see where I'm going with this. It's the use that she's grandfathered and is non-conforming. In fact, this became such a significant issue where I hope this doesn't go in the state, that Idaho had to create a Right to Farm Act. And the Right to Farm Act says that no county, city, and other political subdivision shall adopt any ordinance that declares agriculture operation, agriculture facility, or expansion thereof illegal, or requires abatement or forces the closure of such an operation. Any such ordinance or resolution shall be void and shall have no force or effect. Now, we don't have that in the state as clearly for mining and mineral resources, but I want to flip back to the illustration here. So year one on a parcel that we're talking about, a defined parcel operating under a IDL permit. I go out and buy this parcel. There is a extent of minerals that is known. I borrow a bunch of money to buy this parcel. I get my IDL permit. I'm gonna mine it. Going to provide an essential resource for the county. And that's where I'm at on year one. Whoops. November 19th, 2008, I'm non-conforming. I'm a legally non-conforming gravel mine. Okay, so I know my same extent, but that next day I go out and get a contract to provide a bunch of gravel for Highway 95. So I go and extract a little more out of my known materials. I have my IDL plan. I add a truck. This is my investment-backed expectation. And from the November 21st, 1997 letter from the planning director in Bonner County, Thus, the expansion of the site is occurring under Lynn Scott's grandfathered rights. I hate to bring Lynn Scott's because I'm really talking broadly, but the point is the continued extraction and use of a gravel pit and a mine is grandfathered. It's the use that's grandfathered. Again, you can't nail down what's the expansion. How's it determined? Is it arbitrary? You can't be arbitrary. You know, we're suggesting it's the original parcel and acreage. But, you know, maybe it's the depth of the extraction. You're going to try to suggest that that's your expansion, or the volume extraction, or the yards of material, footprint, employees, trucks, equipment. No one has this information. The limits weren't defined at the time of grandfathering, and none of these property owners have ever been notified that they've expanded their use by continuing their mine. So it's the use, it's the mine. The surface mine was the legally non-conforming grandfathered use. Changing the area of extraction for sand and gravel, it's the completion of the natural resource extraction, the use on the parcel. The characteristic of use and the fundamental nature of the use and the distinguishing trait for extractive resource-based industries is continual expansion. I brought up arbitrariness. You've seen this if you've been here in front of me before, because it's a really big one. 67, 65, 35. LUPA, the land use code that we all follow in Idaho, directs decision makers to impart reasoned decisions when developing land use code that give practical consideration and fundamental fairness to guide their decision making. You can't 1 year send out a bunch of letters from the planning director saying you're grandfathered, and the next year or 5 years later say you're not grandfathered. That's arbitrary and capricious. For the record, I just want to introduce, by the nature of this PowerPoint, but this letter from November 21st, 1997, where Marty Taylor, then planning director, said, thus the expansion of the site is occurring under Lynn Scott's grandfathered rights. That is, the acreage originally developed when the quarry can continue to be quarried. This demonstrates that a CUP is not mandatory for these grandfathered mines to continue expansion on the original property. We all care about the environment. I've got kids, parents, sisters, fish, hunt, love clean water, air. I just want to emphasize the statutory authority and regulation and oversight of mines is granted to IDL and IDAPA 200302, as well as Idaho Code 4715 for the protection of the public health, safety, and welfare. That is the same language that's in your zoning code, that's in LUPA, health, safety, and welfare. If they are absconding their responsibilities to deal with other things, that's not really any of our issues, except we should make sure they are. Health, safety, and welfare is what they are charged to implement. IDL is responsible for administrating these laws and gives regulatory oversight and serves as the catalyst to promote effective environmental responsible mining. So getting to the end here, I just want to touch on a couple of concerns raised by a law firm that I truly respect, Givens and Pursley. Mr. Allen has suggested that the proposed text amendment would unfairly treat the Lynn Scott's property differently than others, and that the adoption of the requested language would amount to for the benefit of a private party. Further, he has suggested that such an action would amount to spot zoning. A very basic review of LUPA would discredit these attempts to target not only the Lynn Scott Sago property, but dozens of other working mines for closure. First, the requested text amendment seeks to treat all legally non-conforming mines operating under an approved IDL plan uniformly. That is critical. In no way does the requested attempt provide Lynn Scott's with special treatment. As proposed, the legal non-conforming mine with an approved IDL plan would be allowed to expand within the original parcel boundary existing at the time operations began. As the proposed text amendments are legislative in nature, they do not relate to specific property, a specific property or parcel, and therefore this is not spot zoning. As you're aware, there's two types of spot zoning. Spot one, type one, requires that you test for being in accordance with the comp plan. Type 2, the really concerning one, refers to a zone change that singles out a parcel of land for uses inconsistent. A parcel of land singles out a parcel of land for use inconsistent with the permitted uses of the zoning district for the benefit of an individual. This does neither. Mr. Allen also has suggested that non-conforming use expansion isn't allowed, that it would be in conflict with Bonner County Revised Code 12341. I just want to reemphasize this. 12341 says that a non-conforming use can be continued subject to the provisions of the chapter, but may not be extended or altered unless necessary to comply with lawful requirements. So when you go to those subject to the provision of this chapter, you go down to 1, the cumulative expansion by up to 10%. Again, we're back to the commercial, industrial, or public uses or structures. This is not a public use. It's not a structure. We're talking about a resource-based use. Gravel extraction, mining are resource use classified in 12336. Only under the most contorted interpretation would one suggest that the continuation of mining on a parcel would be classified as extended or altered. Utilizing such a biased perspective would have resulted in mines being in violation of code with each and every additional scoop or truckload of material removed of source material. The essence of a mine is that continual extraction of material takes place. To call such activity expansion is an extreme reach of any reasonable application of the law. Some concluding remarks. The proposed text amendment, as provided by the applicant, supports the continued provision of raw materials which are deemed essential by the state of Idaho and Bonner County. Bonner County amended code 12616, 2008 adoption granted legal nonconformity status to numerous classifications of land use activities. If the intent at that time, as Mr. Allen suggested, was to extinguish nonconforming uses and for mines after a period of time, and you've seen his response, his rebuttal, that's what he's saying. This is supposed to cease. That's the point of making it nonconforming. Bonner County would have used a different tool and another provision to guarantee their termination. We do this all the time in land use, this diminishing amortization schedule. And such an amortization provision allows for the continued operation of the use for a period of time deemed sufficient to recoup the investment put into it. You see this all the time with signs. If you put up a neon sign and then the city makes neon signs illegal, you're allowed to recover your investment in that sign over a period of time, and then it goes away. But Bonner County didn't do that. They specifically excluded natural resource uses from the expansion. The proposed text amendments provide the clarity to avoid contention and litigation moving forward. This really falls on you and your peers. I'm sure you don't want to be going through these every month, week, or year. It's specific to mines operating within their original parcel acreage, having an approved IDL plan. Code has been misinterpreted. It has always been the intent to leave natural resources uses out of Bonner County Revised Codes 12341. The applicants are not opposed to newly established mines requiring approval through a conditional use permit. We're not here to say go mine anywhere willy-nilly. And finally, I'm really excited to put this up because we got this today. This is from Claire Marley. She was the planning director from 2000 and Bonner County planning director from 2002 to 2015. And she approached me a couple of weeks ago and heard about this text amendment. And she said, what? And as she's clarified in this letter, when I drafted this section of non-conforming uses, I purposely listed commercial, industrial, or public uses and did not include resource-based uses, which includes mining. Mines already have a right to continue extracting materials within the boundaries of existing grandfathered operations without being considered expansion. This right has been confirmed through many past planning directors over time. To decide otherwise would deny mining operations rights set by the non-conforming standards of zoning code. I would urge the county to confirm these lawful non-conforming mining operations have the rights to continue to extract materials within the boundaries of the established grandfathered boundaries, policymaking and or text amendments where necessary. So this is important, and what we can do here tonight with a recommendation of the applicant's text is bring this to conclusion. I hope I've bookend and put some clarity to this, because this is not your typical stuff you're dealing with in planning and these meetings. So there's a lot here. We've got Toby here to put a bookend on this. I just want to emphasize that adoption of the recommended applicant's language will bring clarity to this and avoid lengthy contention and potentially litigation and other issues. And more than anything, it's going to ensure that the materials that our lives depend on are readily accessible to the state, to the county, to home builders, to septic builders, all these modern conveniences that require these materials. So with that, Toby, you want to
Sure, I'll come up there.
put a wrap on this? And then, of course, any questions? And that letter that we just got today, we'd like to put that into the record.
You need to give that to Jim.
Jim.
So she can stamp it.
Okay.
Thank you, commissioners. My name is Toby McLaughlin, Sandpoint Law here in Sandpoint. Been practicing in Sandpoint for about 16 years, been a lawyer for about 20. I just want to address a couple of the issues. I think Mr. Grimm did a great job on addressing the overall, and I'm going to be somewhat brief because I think he was very thorough. First and foremost, I want to address the idea of the staff recommendations, because I think that's kind of hanging out there right now. And I respect and understand why the staff would make recommendations, but in terms of a text amendment procedure, my clients thought very hard and carefully about the text amendment language that was being proposed. And in terms of what's being asked for the commissioners to approve or disapprove, it is that language. It's not a modification thereof. And there's a couple of reasons for that. One, first and foremost, respectfully, we think that the text amendment proposals that the county is offering have almost the exact opposite effect of what we're trying to do, meaning my clients are trying to do. And that is to protect grandfathered rights when it comes to the mining claims. We're talking about grandfathered rights, not new claims. New claims, absolutely. You know, if you're going to put a piece of land in for a new gravel pit, then you need to get a conditional use permit. That makes sense. But if you already had an existing gravel pit or mine as of November 18th, 2008, you need to be able to continue to use that gravel pit just like you have. That's what the text amendment applies. Now, the way the staff recommendation, if you read it literally and try to apply it, it would require a conditional use permit for every single grandfathered mine that exists today. Because the minute somebody goes out there with a shovel and takes one shovel out of a gravel pit, you have expanded it. And remember, the 10% versus 50%, that doesn't apply to gravel, to resource-based uses. It just applies to those other types of uses. So if you're talking about an expansion, you take one scoop out, according to the county's recommendation, every single mine would need to go get a conditional use permit. That would shut all mining down in the county. That cannot be I'm not saying that's what the intent is, but that is what it will do. So we are just asking for a recommendation from the commissioners as to the language that's proposed. I would also point out that the recommended language, the staff has recommended, hasn't been published. It hasn't been considered by everybody. Everybody in the county didn't have a right to look at it before, in time to look at it and come in here today. So getting to the actual language itself, I will just point out, Mr. Grimm pointed out that the Idaho Constitution, Article 1, Section 1, it specifically addresses the complete development of mineral resources of the state as a fundamental objective of the state of Idaho. Now, that idea is reflected in the current Idaho statute 676502, which talks about the purpose of local land use planning to promote the protection of mining lands and lands for the production of minerals and economic benefits. Idaho Code 676508 states that it is the duty of the Planning and Zoning Commission to conduct a comprehensive plan process. And in that, The commission is to shall consider land uses, including considering of mineral exploration and extraction. Bonner County's own codes and ordinances reflect this. Mr. Grimm pointed out, Bonner County Ordinance 501 specifically says it's to the new Title 12, which is the replacement of the old one in 2008, to encourage the protection of prime agricultural, forestry, and mining lands. Bonner County Resolution 1829, mining production in the county contributes to the livelihood and well-being of many of its residents and contributes significantly to its economy. The county must strive to protect its mining heritage. And the county must protect its vital natural resources that are necessary to keep these enterprises in operation. I point this out, not to rehash all of it, but to point out that literally from the Constitution down to the Bonner County Code, every level reflects the importance of protecting mining. And the reasons are obvious. Mr. Grimm put it up there. We literally use aggregate from mining pits and gravel pits in everything. And if we were to have to go out and import those from out of state, anytime we wanted them, that would cost every one of us a lot more money, not just for private projects, for housing foundations and everything else, but for public roads. You think about the highway expansion that's going on out in 95 by Granite Hill. Fortunately, the Peaks have a gravel pit right there. That saves us all money. If it didn't, that project would cost a lot more money, and that comes back to us as residents of the state of Idaho and the residents of Bonner County. So that being said, the text amendment itself, the first part of it, all we're trying to do here is bring it in conformity, bring the very first part of it in conformity with how the county already treats non-conforming uses. The Title 12 was repealed in its entirety in 2008, and then it was replaced. And the county, in my experience, has been treated, whenever I call and say, well, this is in use, is it allowed? The question I always get is, well, was it before November 18th, 2008? If it was, the answer is yes. The county doesn't go back and say, well, was it allowed in prior Title 12? It just says that's what it is. And so we're asking simply to have the text be consistent with how the county's treating every other, as far as I know, every other part of the code. Now, one thing I think that's important is 12-341 subsection 3. Now, one of the things Mr. Grimm said was the current version is causing confusion without subsection 3 because it doesn't address natural resources. So people have confused it and said, well, the 10% or 50% limits apply to natural resources. In fact, Gary Allen, the very attorney from Gibbons Pursley, thanks. He himself, who's a land use attorney, made that same mistake. If you go read his letter, he says in there that all gravel pits have, he's actually talking only about the Linscotts because he's for some reason targeting them, but he says they can only expand in those ways. So even he's confused by the way the Bonner County Code's written. Now the staff and Marty Taylor, Claire Marley, prior planning directors, all of them have said that code provision doesn't apply to natural resources. So what we're trying to do is make it clear. And what we're trying to make it clear with is non-conforming grandfathered uses only. That's what we're talking about. So it does need to be cleared up. Now, I think it's important to notice, what we're talking about here is extraction-based natural resources. And part of the reason I'm up here talking about it, not to repeat everything Jeremy said, but there's a legal doctrine called the Doctrine of Diminishing Asset. And it's recognized by the majority of jurisdictions in the United States. It hasn't been considered in the state of Idaho as far as I can find yet. But the concept has been explained by the Washington Supreme Court, our sister state. And it says, I'm just going to read part of it because I think it illuminates why we need this code section. It says, courts have observed that the very nature of the excavating business contemplates the use of land as a whole, not a use limited to a portion of the land already excavated. Such a diminishing asset enterprise is using all of the land contained in a particular asset. As a practical matter, it must begin digging at one spot and continue from there to the boundary of its land. The entire tract of diminishing asset operation must be regarded as a lot within the meaning of an ordinance which permits a non-conforming use to continue on such a lot. For to hold otherwise would be to deny the excavator his use. Now, quarry property is a one-use property typically. You dig out the gravel, use the gravel. If the code is applied to say any expansion at all, which could mean literally a shovel use, an extra truck, anything, then you're essentially shutting down all current mines unless they go get a conditional use permit. And that could directly conflict with 12-340, which allows for non-conforming uses. So you end up having 1231 or 123041 conflicting with 12340. And I would point out also that a non-conforming use under 12340D is defined as uses which were lawful before this title was passed or amended. Now, they're talking about 12-34 or Title 12 in 2008. But the reality is mining uses are not unlawful, even in a residential zone. They're allowed, they're just regulated. They're not unlawful. So they don't fall under that direct definition. So all we're trying to do is clear that up. And I think the language as proposed does that. In terms of Mr. Allen's comments, if the commission has any questions on it, I'd be happy to. I think Mr. Grimm covered it, so I'm not going to go into that. If he does testify, if he's here or he testifies on screen, I would like, if we have a rebuttal chance, I'll address it then. I think the last thing I'll say is that essentially the applicants are respectfully submit that the proposed amendment language of the text of Bonner County Revised Code 12-341 promotes the public policy of encouraging the development of public resources, which is stated right in our Constitution. It protects local jobs, minimizes material costs and cost to all of us, and it ensures fairness to those local running mine operations that were in existence as of November 18, 2018 or 2008. Also, in terms of public health and safety, IDL is already in charge of that. IDL is literally dictated to take care of public health and safety when it comes to mines. They regulate it. They're here to do that. That's what they're for. Frank, with all due respect to the county doesn't need to duplicate the work or do the same things that IDL does. IDL does enough. Plus, there's the Department of Environmental Quality. If somebody did have an issue, they could report it to those agencies and the IDL would investigate. So I would just ask the court or the commissioners to approve the current text language unless you have any questions.
Any commissioners have questions of Mr. McLaughlin or Mr. Grimm?
I do, either Jeremy or Toby. So a lot of this appears to be hinging on the presence of an IDL reclamation plan. In your experience, when somebody has whatever, a property that's 100 acres, what does that plan cover when they get it from IDL? Is it the entire 100 or is it what they propose to use on some reasonable basis?
I frankly don't know the answer to that question because I don't own or operate a mine. So I'm sorry, I just can't answer it.
Okay. I don't know, Jeremy.
I have the same question. So
Address
it's
it.
pretty important.
Yeah.
Jeremy Grimm for the record. My understanding that there are a variety of not constraints, but thresholds that a plan can move through based on acreage. So some are limited to 30 acres. That's the current plan. You finish that, amend your plan, take the next 30. But I can't speak to the specifics of what those thresholds are. Maybe someone during public comment will.
And I must divulge that in my former life as a civil engineer, I developed at least one reclamation plan for a pit in Bonner County, and it was only for a portion. So the discussion came up, what about expansion? About, let's not use that word, continuing on with the property. And IDL said, then come back. Once you've done that, the question was, because reclamation plans show how to just that reclaim the property, so you get to an edge that would potentially go that way some. And you brought that to a certain slope. You have to do that if you're going to keep going in that direction. So that's one of the.
My understanding, there's deference given to the vision for the pit. because those 3-to-1 slopes and the drainage, so when it's all done, but they bite it off in chunks.
That's my understanding that it can be done that way. So, but still, when it comes to that, they have a reclamation plan for a portion of your entire holding. Is it purely up to the minor to then go back? Or is it IDL says, wait a minute, you only went to here, now you're 10 feet beyond, what gives?
Well, I would suggest, like with any other regulatory scheme, it is first and foremost on the owner of the property to comply with that law. And in the instance where the law requires them to get a new reclamation plan or amendment to the reclamation plan, that's what they'd have to do. And if they didn't do that, I think they could be in a lot of trouble. But I would respectfully suggest that it's not an argument in favor of the county stepping in. I think that's an argument just that IDL would be doing.
It seems like if they're the regulatory agency in that sense. Thank you.
Just to follow up on Commissioner Davis' question, we received some comments from IDL, and this is for either Mr. Grimm or for you, Mr. McLaughlin. And they seem to say that a reclamation plan is only for specified, the acreage specified in the plan, which means that there are boundaries to even the permitted use under the IDL reclamation plan. So in looking at, Claire Marley's statement there, again, she's referring to the boundaries of the existing grandfathered operations. So that's not necessarily the parcel, that's the boundaries of the approved reclamation plan. So isn't the logical interpretation for a conditional use permit whether or not the boundaries are expanded, not whether there's another shovel?
Well, I think that could be, interpreted several different ways. I haven't seen it actually defined yet because I don't think there's a case on it. But I can understand that idea, but I think that argument actually is in favor of not having a conditional use permit. Now, I say that only because the reclamation plan that's required in the proposed language requires that reclamation plan. In other words, you don't qualify under there unless you have a reclamation plan. And so you'd have to go get an expansion.
You have an opportunity to read the IDL comments?
I did read them.
Well, it says in there that the county has a role because they don't regulate all aspects of a mine. So they're saying in there that for public safety and other issues, the county does have a role in regulating that type of use, even though there is a strong public policy in favor of mining. It seems to me the IDL itself is saying, first, there's no preemption, and second, the county does have a role. You wouldn't disagree with that, would you?
No, and I think the role is in defining where a new mine would be. In other words, I understand the way I read those comments is say, if there aren't any impacts on or expected impacts on wildlife or water quality, then we won't necessarily turn those over to the Department of Water Quality or those things. But if there are, then they will. I mean, the Linscott mine in particular, we have records, excuse me, that it was sent, their reclamation plan was sent to the county and for their approval or their comment.
Are there any other questions of the applicant?
Just like to clarify and add to that just a little bit. You'll notice in our text amendment, we're pretty thoughtful about this in the sense that we're not looking for an expansion within the current boundaries of an IDL plan. Okay? You read it, it says they stand within the parcel boundaries existing on 11/18/2008. We're trying to provide very succinct terms and clarity to where we are trying to authorize the continued use, the grandfathered use of these mines. Of course, they have to comply with IDL plans. IDL notifies Bonner County when new mines are being proposed, plans are being addressed. So, I think we're getting off track. The focus of the text amendment is specifically to authorize the expansion, continued extraction of mineral resources within the parcel for boundary as a grandfather use. The mine is the grandfather use on that.
So whether or not the parcel boundaries have actually been approved by IDO?
Well, the active mining reclamation plan is a subset of the mine. The parcel boundaries, is the parcel where the grandfather use would be allowed for continuance.
Any questions? Any other questions?
I have a question. Jeremy, did I hear you correctly when you said that the Linscott's they're not at all open to any amendment to what they submitted?
It's not just only Scott's, it's a broader sector of
Right.
industry I'm representing. Correct.
Okay.
We would like effectively a thumbs up or down per the application as submitted.
Okay, is there anything in the staff's comparable paragraph that you would consider, or just that's a no?
The main impetus or the flaw in the staff's recommended language is that it would trigger a conditional use permit.
Right.
Yeah, and that's, I mean, again, we're hoping to avoid this turning into a court battle. We believe that there's copious evidence in the Constitution and case law that supports grandfather use. We're trying to provide you a very clear and simple way to fix this misinterpretation.
Just wanted to make sure I heard you correctly.
You did.
Thanks, Jeremy.
I guess that prompted me to ask another question, and maybe either one of you, I don't know. Is there any case law that would indicate that the imposition of a CUP requirement in and of itself would be a violation of these constitutional provisions that protect mining uses or any other code provisions in state law? I mean, before you even consider what the conditions are, you have to go get CUP.
No, I don't think that issue has yet been addressed by our legal precedent. It just hasn't. I mean, Idaho is a small state, so we have a limited amount of legal precedent. And it just, like, for instance, that doctrine of diminishing asset, that just hasn't been considered yet in Idaho, even though it's been considered in almost every other state. So it just takes us longer to get there, unfortunately, or maybe fortunately.
Frank Potter, I'd also add that that's really not the question at hand. The question at hand is when you apply for a permit, and you're granted a permit, is it the time of the code that's in place when that activity is initiated? In 2008, this property, this use on this parcel became grandfathered. It's a legally non-conforming use. That use is the extraction of minerals on the property. So you then go back and suggest that you now need to get a conditional use permit to implement your rightful, non-conforming use would be contested for sure. I can't cite the cases, but that is, as far as my understanding, not an attorney, just for the record, that is the witness test.
If I could just address one more point, I would say there are cases out there that do say that, in the imposition of a conditional use permit, if it eliminates your ability to use it, or anything can be considered a taking. If you all of a sudden you have a grandfather right, and then a new zoning or new regulatory scheme comes in and it changes that without just compensation, then it can be.
But that would have to be based on what the conditions are.
Yeah, it would be case specific, I would think. Yes.
I mean, I could envision a set of conditions that would really prevent them from continuing the use that they had, and it would be a take clearly. But there also could be conditions that were, I'll say, mild enough that they may not rise to that standard.
Yeah, it's case by case.
That's why I asked, just the imposition of a requirement to obtain a CUP, separate from any consideration of what the specific conditions are that apply.
Well, I think if you were simply to adopt, frankly, if you were just to simply adopt a requirement for all grandfathered uses and say, oh, as of today, grandfathered uses, you're no longer legal unless you go get a conditional use permit. I don't think that would be allowed. That wouldn't be upheld because you are.
But that's not what we're saying.
Right.
We're talking about an expansion, correct?
That is how the code. Well, no, I mean the way it's.
The code isn't clear about that, but what the staff is recommending.
Yeah. I was going to say that the way I read the staff report, that's what it would require. Yeah. Thank you. But, yeah.
Make one. So in the staff report, number 5, they talk about the last sentence. The second sentence in the proposed text, for the complete development of the material resources of the state or any of the necessary means to their complete development or any so forth. seems to be a statement specifying the intent for requesting this amendment. It is, however, not required to add any clarity to the proposed amendments. What do you think about?
I think the point of that language is it's taken right out of the Article 1, Section 14 of the Constitution. So it's intended to make sure that public policy is right in the code. I think that's its intent.
So, and that's a principle that we've talked about a lot. How much do we just plain reiterate what Constitution, what state code says in county code? Yeah, it can be done, but
Understand.
how many times do you have to say it?
Understood. Thank you.
Thank you.
All right, so is that the completion of the presentation by the applicant?
I believe so.
All right, so we'll go to public comment. Or is there any public, obviously there's public comment. I would just ask people to limit their comments as possible to 3 minutes. You can give your 3 minutes to somebody else. Please don't repeat what another speaker has said. You can just acknowledge that you're in agreement and try to keep it on point with the issues that are before the commission at this time. You have a public comment, Mr. Overton? All right, do we have any public comments in favor of the proposal? Sir, state your name and address.
Gentlemen, ladies. My name is Brian Wood. I am the owner of Wood's Crushing and Hauling, a local company here, been in business for 47 years. We manage and operate 8 of these sand and gravel quarries in Bonner County. We have 70 employees. We have an annual payroll of nearly $4 million. I would venture to guess that we nearly spend that much money in supporting the local economy, whether it's fuel, parts, service. So we produce roughly 500,000 tons of material a year out of these 8 sources. 500,000 tons to the people of Bonner County. That is 33,000 truckloads. I'm trying to tell you the demand that is required on these natural resources, these existing gravel pits. 33,000 truckloads. You couldn't walk over that pile in a week. We have to have the ability to expand these sources, or I mean, we can haul from Coeur d'Alene, but folks are going to pay the bill. That's the alternative I think we're faced with here. So this material is used in sand and gravel, for roads, asphalt, concrete. I think that's what we're trying to do, is make it an easier pathway to keep these sources in operation. Now, we're not asking to do anything illegal. Your reclamation plan, we have to have a reclamation. On whatever we do, we have to have a reclamation plan. A lot of reclamation plans will be in different phases. You'll have phase 1 mining, phase 2 mining, phase 3 mining. They're built to be transferred, for a period of years. And you can easily go get a reclamation plan to expand a piece of property. I mean, to be able to expand your mine. Your reclamation plan is done by Idaho Department of Lands. They govern what you can do. Your setbacks, your slopes, it's regulated. We, as in the mining industry, are regulated by DEQ. We're regulated by MSHA, Mine Safety and Health Administration, Department of Lands. So we just need a pathway to be able to continue mining these properties that we own and manage. We're not asking to lessen our setbacks, but if we own a piece of property and we can keep it within our setbacks and keep a reclamation plan on it, we should be able to expand it.
I got a question for Mr. Wood.
Okay.
So Brian.
Yes,
so
sir.
On your 8 properties, you have rec plans for all of them and they're staged. Okay. So when you get to what you know on the plan says, okay, we're at the end of stage 1, we need to go to stage 2. What's the process for?
If you have a reclamation plan that has your phase 1 mining, your phase 2 mining, it's there. It's already done.
Well, it's done. Is there a difference between the, I don't know if the setbacks have changed, but just that phase 1 is here and it's got reclamation slopes that are required and depths and everything. That area you're going to expand into, is that a prescribed slope or do you have?
It would be the
that?
same as your original
You just
phase
keep
1.
moving to the
Yes.
west, east, north,
Yes.
south, whichever direction.
Yes.
And, but if it's in its phase like that, so you have to notify IDL, we're going in phase 2, and phase 3, so forth, or do they come out and look, or what's going on?
They will come out and look and call. If you call them, they'll come out and inspect what you're doing, which is a process that we try to do. Sometimes it's hard to get them to come around, but
Yeah. And to your knowledge, are reclamation plans available to the public to look at?
as far as I know, public information that go to the Department of Lands, and I wouldn't, I guess I can't swear to that, but I think so.
I think they're public plans.
The
right?
public
Okay.
agency.
Just wanted to get that in the record.
Yep.
Thank you, sir. I have also Lisa Lauda. Is that right? She indicates she wanted to speak in favor. She's not here. One other 4, that's Scott Gusto. I'm sorry?
Scott Rusho, yes.
Yeah. Okay, you don't want to speak. That's fine. You don't have to speak.
I can answer some questions.
Okay, then we'll go to those who are opposed. First one is Rihanna Sharp.
I don't want to speak, but I'd like to donate.
Okay.
Which leaves me.
Next one is Joanna Plant. Joanna Plant.
I didn't realize there was a shortage on gravel because that's what it sounded like when I was sitting back there. Look, in 1981, there was non-conforming land laws. And since non-conforming land is set up to end in the future to prevent issues of overgrowth, the limitation with growth is placed on the operation by the timestamp, and the growth exceeds, then a conditional use permit is required. I'm kind of confused why it's so hard to get a conditional use for permit. There's conditions that can be put on that doesn't limit the growth or limit them. I'm confused by that. How many times in the future will we rewrite the code and then restart this clock again? We're already restarting it from 1981. Now we're going to restart it 2008. Are we going to have another rewrite in 2026? This is setting a precedent again for rechanging that timestamp. The county claims that this resource code is not in non-conforming land use. But I want to point out if you look in the document of 341C, right before 1A and B, it says that surface mines are in that. It talks about surface mines if they're abandoned and within 2 years that they're abandoned. So why would they bring up surface mines in non-conforming land if the resource base code isn't involved in that? Surface mines was in that. So that doesn't make any sense to me. So that was 341C. You can see that. Also regarding the original rural land, I wanted to point out, since Lynn Scott's is being, are we talking about going back to when they owned it in 1981? They had one parcel. Then after 81, they went to a different parcel. Do we add that one? That was after 81. Then do we add the one that was purchased in 1991? Or what about the one that was the neighbor's property and they dug into that, so they purchased that property? Where exactly is the timestamp that we're going to call when they are considered grandfather? Then that goes into the 30-acre parcel, 1997. Yes, reclamation plans are public. That's why I know this information. Said they were 30 acres, expanded and disturbed. The next year they said the same thing. The next year they said the same thing. It went all the way through, and the reclamation plan continued to say that through 2015, 16, 17, and 18. Where are we supposed to go? Are we supposed to take his word? Because if that was the case and we go by the reclamation plan in 2018, he said he had 32 acres exposed.
Yeah.
We're talking about reclamation plans, right? I know Brian's trying to stop you, but
No.
we're giving
What
the
we're trying to do is analyze the proposed text amendment.
Is the
Staff recommendation.
Is the reclamation
Not
plan
any
supposed to be
particular parcel
the
plan.
controlling property? Is the controlling document? If that's the one we're going to, which one are we going to go to? What the person puts that they're disturbed?
That's not before us.
It is. You're deciding whether the reclamation plan is going to be the deciding factor on the growth, on what it is. That's what you're deciding right now.
I understand.
Okay, so that's which one are we supposed to go by? Plus, he just expanded that to 2019. It was, he could do 100 acres. He just went to 154 acres. Now, I just want to point out, somebody could have 200 acres and they started out at 17 acres and nobody even knows they have a gravel pit. They can keep expanding and expanding to the very edge of their property, but I can tell you that no Idaho non-conforming land use goes parcel to parcel edge. It goes from the size of when it originally started, and then there's a growth expansion to that. You can't just make the law here in Bonner County when no Idaho law does that. But I guess we're going to try to do that here. It's very confusing. And I just want to point out also, when regards to the non-conforming land use and our revised code, the Supreme Court decision was in regards to the non-conforming land use that we did in 2018. We took the pit and their non-conforming land use and the growth to the Supreme Court. The Supreme Court agreed with us that, and they were looking at this revised code and what was it said, and they said the county acted in a manner that was arbitrary and capricious in refusing to address the gravel pit's compliance with the non-conforming use provisions of the Bonner County Revised Code. We award Citizens Against Lynn Scott the reasonable attorney's fees and appeal. They also said in the same decision document with the Supreme Court, it is difficult to imagine how a fact finder could conclude that the gravel pit is in compliance with the non-conforming use provisions of this code that we're talking about right now. The Supreme Court agreed with the citizens' non-conforming land use and had the same opinion that quarries and surface mines are part of the non-conforming land use laws.
I understand that. I appreciate the history lesson.
So you're interrupting me on my argument.
No, we're not litigating here over the Lynn Scott parcel.
I've never had him. So you're just going to argue with me while I'm trying to say my.
I'm not arguing with you.
Okay,
I'm just
then I'll
asking you
finish.
to address what's before us.
You've got to be joking. Okay, that's what is before us, is allowing non-conforming land use. And what we're going to start when their land use starts. When is their grandfather land start? Is it starting in 1991? When is it starting? Are we going by which thing? What revised code, old, going by compliant? Or I'm absolutely shocked that most gravel pits in Bonner County have, by the way, gotten a conditional use permit. Are we going to make all those that have been legal? Are we going to punish them? Because I'm confused. From 1995 to 2003, 35 conditional use permits were given. What about those? Those 35 people knew that the law.
Have you read staff's recommendation?
Yeah, and you know what? I talked to the attorney, Gary Allen's our attorney, and he absolutely loved the staff because he said it made it legal. A lot of the staff recommendations made it legal. He said it was absolutely against the law without the staff recommendations. And I told Milton on the way here, thank you, Milton, for whoever put that together because it actually made it applicable and legal because of.
So just so you're clear that you would support the staff right?
There, I think there is a few details that need to be, but the staff recommendations made it way better, but they're absolutely refusing to do that. So I don't see any purpose to continue with that. I guess I'll just finish since you really didn't let me.
All right, next is Tom Walton. Oh, Sharon, well, okay.
I'm
Both of
Sharon
you are here.
Walton, and I live at 320 Meadow Lane, and I've lived there since 1989. Actually, 88, 89. We've been dealing with our gravel pit, which is Lynn Scott, for that many years. When we moved there, we were told he was not a operating pit, and he never bothered us. Then pretty soon things started changing, which I know we all need gravel, we all need jobs, we all need, roads and stuff. But I feel that, like Mr. Woods, he abides by the law. Sorry, Mr. Lynn Scott did not. I remember calling the sheriff and having the deputy go over there and talk to somebody that was working way past the user permit. And he came back and said, Mrs. Walton, I need to go and talk to Mr. Peak. And he did. He calls me back and he said, well, I'm sorry. He didn't know that his employee was working there. Now, how many bosses would not know your employees working?
I understand there's issues with how Mr.
Right.
Scott may be.
I'm just
operating his plant.
concerned that our quality of life, we can be good neighbors, but they haven't been good neighbors in the past. I can't answer for any other gravel pit. I only know what we've dealt with, and that's our concern. I'm not against the gravel. I'm against them trying to put an asphalt plant there.
Okay. Well,
Okay.
That's not before us. So
Well, but I appreciate you listening to the residents that are around the gravel pits. If they're abiding by the laws and they're not encroaching on other people's property, that's great. We all know that you need gravel. So thank you.
sure. Thank you. All right. So we have Mr. Bowman. Susan Bowman.
Yes.
Hi, Susan Bowman for the record. I am just, I have a question, really. It's more of a question. So the Givens Pursley, I read through the whole application and I read through, and I listened to this today, and I read through the Givens Pursley 6 pages that they had, and I'm sure that you read through it too. And what I'm concerned about is that the county doesn't have a legal analysis of that. So I don't know if Bill is going to do that tonight, but to protect the taxpayers, it seems like we would want to have a legal analysis on the county side. That's standard procedure with planning. From the way I know it, is that if you have a lawyer that is coming up with really good legal case arguments based in case law, you really want to have the county protected and the taxpayers protected. So I'm just curious if we're going to be doing that tonight. Maybe Bill can talk to that. Thanks.
Mr. Wilson is here for questions. Do we have any, Mr. Wilson? I doubt it. Okay, I think that's all the public comments I have. Anybody else?
I have one question.
To address name and address, please.
John Murray, 442 Sunrise Circle. I just want to be clear on talking about 10% expansion. And that this refers only to taking gravel out. And I read it up here somewhere that it does not refer to other types of businesses
What I'm talking about is if that's the case, then an asphalt plant is not admissible to be put in the Linscott pit.
That
Being that,
doesn't really
that
follow.
you're only allowed to expand 10% and it needs to be mining, it needs to be removing the gravel.
10% refers to the expansion of any non-conforming use as defined in the code. So
And somebody mentioned 10%. I was told there's so many problems that Linscott didn't address the driving of the trucks and having the right property, the road. True or not, he's down into the aquifer and he's dug into somebody's land. All these were required for the original permit and they're still not being addressed. Are they going to continue on that road or is it finally going to get addressed or not?
not before this commission. This commission is only looking at a text amendment to the code. If there's non-compliances with the reclamation plan or there's non-compliances with other zoning issues, then that's going to be taken up in a different manner.
Okay.
Thank you, sir.
So we won't know
Not today.
if an asphalt plant is going to be allowed or not.
That's nothing to do with us today.
Okay.
We do have 2 people online.
Okay. Thank you, people online. State your name and address and whether you're for or against.
Hi, my name is Susan Drumheller, and I'm not sure if I'm for or against the staff revisions or not. I am against the applicant's proposal, and I oppose their amendments because I'm particularly concerned about codifying the expansion to the parcel boundaries without a new or revised conditional land use permit. This amendment appears to be to create a codified exception for one industry, not one operator, that can have major impacts on the health and general welfare of the neighbors. And reclamation plans, I appreciate some of the discussion that the commissioners had, because I was wondering about that too. Reclamation plans are not a substitute to a conditional use permit. Those comments, I read them as well from IDL, pointed out that there is a role for zoning codes and for regulating these uses to make sure that impacts on neighbors are addressed. And the reclamation plans only really address reclaiming the land once the mining is done or the resources are depleted. And I also share Jonna's concerns about the timestamp. I mean, it just seems like, oh, well, we want to move this to 2008 because, you know, these people have more property and they want to expand their operation around more property. But, you know, if you go to the boundaries of these properties, that could have pretty significant impacts on the neighbors. So I think the conditional use permit process is appropriate. And yeah, I just share a lot of the concerns that other people have raised, and I think that the staff has identified some of those appropriately. Thank you.
Okay, thank you. We have another speaker.
Hello, Reg Crawford, Sandpoint, Idaho. I am opposed to the applicant's proposal, and I agree with Jonna Plants and Susan Bowman's comments. The county has spent an excessive amount of money since 2018 trying to amend the code for pits and asphalt plants with no success. While I do agree with Mr. Grimm that this amendment would not just affect one pit, it's imperative to note that all proposed past efforts, as well as today's, would directly benefit the Linscott pit. The elephant in the room is that the Linscotts are today's applicants and are paying a planner and attorney, and we can't just dismiss this. I want to repeat that there are pits that have been and are currently operating lawfully. Where is the necessity if there are pits that haven't been out of compliance? To continue to try to adapt code to make an egregiously expanded pit legal is vexatious planning at best. I've read the staff report and the letter from Attorney Gary Allen. While there may need to be some clarification of the code, there is no necessity for this application as written, grandfathering back so far. The non-conforming use permit is defined by law to function until the non-conforming use can be eliminated, not to be continually or retroactively permitted over and over. Mr. Allen clearly lays out how this code amendment will once again be found illegal. How much more taxpayer money is the administration prepared to frivolously waste on unnecessary code changes? As Mr. Grimm stated, LUPA requires uniform rules, and these amendments would indeed favor the Linscott pit, as new pits would be held to be legally compliant, where the Linscott's illegal growth would be acceptable. And I'd also like clarification. The applicant's team reiterated that they want the code adopted as the application was submitted and not as the county staff report addressed. I agree the staff report varies enough and that this commission needs to either dismiss the planning department's recommendation altogether, or this application and the staff report needs to be addressed and the proper notification process followed. To summarize, I've heard the applicant's team repeat the one scoop analogy over and over. Perhaps the code does need to be addressed to define boundaries and to delineate the IDL rule versus the county laws. But to refer to this application as merely housekeeping is insulting to the pits in compliance and this commission. I respectfully request the commission deny this application. Thank you.
Thank you. I missed another page. Do we have any other? Okay. We have another speaker online.
This is Christine Logue from Blanchard, Idaho. I also wanted to just, what the last two speakers have said, really hit it on the nail. But what I'd really like to say is that the people out here in Zoom land, if they wished to grant their time to somebody else, I wasn't able to make the meeting tonight due to voting and all the other things that go on later at work, voting, etc. Wasn't able to make it up to Sandpoint on time. It would be nice that if the people online, if they wish to grant their time to such persons in time, maybe they could flip flop it and do the people on Zoom first before they did the people in the room. I'm not sure how that works. I just wanted to say that I also agreed with Jonna on the last speaker on their comments as well. And I do think that there needs to be more notification. And it just seems strange how Jeremy Grimm was up there saying this doesn't have anything to do with Linscott, but yet it has come full circle around to the whole Linscott thing. I think that it needs to be further investigated, and it shouldn't be up for approval or denial this evening. Thank you.
Thank you. Okay, any others?
Me.
I have a list of.
If you want to speak, go for it.
I have a list of people who were in favor, who didn't raise their hands before. I'm sorry, ma'am.
That's okay.
Are you?
Wait.
Anybody else like to speak in favor of it? I know there's the Peaks are here, several other people. Anybody else? Okay, ma'am, you can. Oh.
I'm sorry. I didn't know which sheet to sign in on, so I can wait, but I'll speak.
Okay.
My name is Lisbeth Murray, 442 Sunrise Circle, and I would like to donate my time to Jonna. She has a lot more to say than I could ever say, and I support her 100%.
I think she's spoken, so we gave her plenty of time. Go ahead, sir.
Yeah, I'm Jake Ray. I live out in McLeod, 94 Campbell Point. And I don't have a lot of history or anything else. I'm just listening. It's coming down to the county staff report recommended a CUP as a Band-Aid. I'm curious, is the CUP a better tool for compliance than what's already there? You have the IDL in place, and they're the ones dictating what needs to happen. So if Bonner County is going to enforce compliance based off of that, why isn't that good enough? Why is a CUP needed on top of that? That's all I had. I am in favor of the recommendation from the applicant.
Okay, thank you, sir. Anybody else wish to speak? Okay, we'll close the public hearing.
Yeah.
Wait. Oh, I'm sorry.
This is a clarification question. I know you guys aren't required to answer questions, so this is just addressed to anyone who might be able to answer it. So just so I'm clear, there's a paragraph proposed changed to the Title 12 subsection. You're adding a new subparagraph, which would outline lawful uses for non-conforming uses. This is trying to determine if the use of the land, extraction of diminishing resources counts as expansion or not. Thank you.
Yeah, we need your name and address.
Anissa Keith, Sagal, Idaho.
Thank you. Could we have somebody close those drapes because the sun is. There
aren't any.
All right.
This was a government building.
I can't afford that.
All right, we'll close the public hearing then, and we'll bring it back to the comments from commissioners.
Sir.
Oh, yeah.
Rebuttal.
Okay, rebuttal from the applicant.
Jeremy Grimm, Whiskey Rock Planning, for the record. Yeah, I just want to mention a couple of things that were raised during the public comment. First of all, as quite obvious, this isn't about asphalt plants. It's not about the Lynn Scott's property specifically. This is a legislative code change that would affect all legally non-conforming quarries and pits that existed on that date, that November 18th, 2008 date. That is the date that the code changed and parcels became non-conforming. The uses established as of that date are legally non-conforming or grandfathered. I just can't emphasize strongly enough. There's nothing that suggests in case law that non-conforming uses are required to be terminated. If that was the intent, there is a very practical tool used by planners and lawyers that would have established such a termination. That would be the amortization of investment into the pit or whatever use is being terminated. And again, I also want to emphasize, if you look at the application and the code that's been presented, this is not about requesting grandfathering of the footprint of the current IDL plan. It states specifically, this is a request for grandfathering and clarification of the use, the non-conforming use of the parcel boundary as of November 18th, 2008. And the qualifying parcels have to have some sort of IDL plan. It doesn't specify that it's the footprint of the plan or the phase of the plan. It's just showing that these are legitimate, ongoing, recognized, legally reviewed mining operations. Beyond that, appreciate your time. I know this has been a lot to digest, and look forward to your decision.
Thank you.
Could I make one comment?
Sure.
Very quickly. I think I want to give you guys an example because I think this is what actually this text amendment is intended to provide. Imagine for a second, you buy a gravel pit or a property that you intend to make into a gravel pit. Like Jeremy said, you do a quantification of the amount of materials in there, you pay a certain amount of money because you expect to be able to extract those materials and sell them. It's a business analysis. So you start making a query, you get a reclamation plan, you start doing your business. And then the county comes in and changes your zone and says, okay, now you're suburban or residential or something else. Now, according to Gary Allen in his analysis, the point at that point would be the public policy would be to eliminate that use. Well, that, first of all, I don't think that's in the public policy given the Constitution and the state codes, express intent to develop all natural resources to the fullest extent possible. And second, and which can't be ignored, is the investment-backed expectations of that person who bought it. Are they then limited literally to what they have dug so far? Now, can they dig down? Is that not an expansion? Or can they dig 1 inch sideways? Or, the problem with that is it becomes confusing. And frankly, with all due respect to the commissioners, the county commissioners, the planning and zoning commissioners, all of you, you know, the better people to regulate mines are the people that are in charge of it, the IDL, the DEQ, and those entities that are already in place. I mean, keep in mind that any expansion still would require an expansion of the reclamation plan. And the code as written, as we're proposing it to be written, would be limited to the boundaries of the parcel at the time. IDL would still require setbacks. It's not as if you can still, you know, you can cut a mine 400 feet deep right at the property line. It's not allowed under federal law or state law. So, you know, I would suggest that there's already regulations in place. This only makes that clear that only those grandfathered mines can still continue to operate, because frankly, you can't continue to operate a gravel pit unless it continues to expand. Thank you.
Thank you, sir. Now we'll come back to the commission.
You want to hear from staff?
Sure, staff has more comments.
Sorry, Swati from Planning for the Record. And I just have a quick comment on what was presented today. Staff is not against the expansion of legal non-conforming mining operations. We are very much in support of those expansion, but all we are proposing is that they be restricted to with some conditions to ensure public health and safety.
Okay, now we'll come back to the commissioners. Any discussion, motions, whatever?
I have a question for Bill. There's been some comment that we may be limited to just making a decision on the text as it was noticed in the public notice. Is that true? I mean, what latitude do we have to consider either modifications to the applicant's text or the staff's text, or modifications to the staff's text?
So this, and by the way, my name is Bill Wilson. I work for the county. So I advise the planning staff and others on these sorts of issues. And I do believe that because this was an application submitted by a private party, if it's their prerogative. So if they want you to give an up or down vote on the language that they gave to you, that they submitted originally, then you should confine your recommendation to that language. We kind of fall into the habit of having a give and take, add some language here, take it back, because the majority of the amendments that you see are staff generated. And as staff typically works with you guys to secure your approval and hopefully get that recommendation that then goes up to the board. But in this case, it is their application. So if they would like you guys just to look at the original language, then you should do that. Okay?
Okay, thank you.
Thank you. So I'll go back to the applicant. You made it fairly clear, but I just want to make sure the commission was inclined to adopt, to approve with staff recommendations. You would be opposed to that? You want an up or down vote? Is that right?
That's correct. Jeremy Graham.
All right. Any other?
Could I clarify that just slightly? The very first part in the very subsection 1, I think it is, they were not opposed to that part being the county's recommendations with respect to that part. But with respect to subsection 3, that we would like an up or down vote on that. And I think subsection 1, if you remember, was just, I think the way Swati put it was just referencing 2 other code provisions in there to make it clear that as to what it would apply to and what it did.
So you're okay with staff's report on number 1, but not any changes to number 3?
Exactly. Correct. Thank you.
Any other questions or any discussion? Motions?
Well, I would say first, you know, with regard to the whole discussion of CUPs for existing mines, it seems to me that it's pretty clear. If you look at IDL's comments, they even acknowledge that there are areas of public interest, health, safety, welfare, that they do not address in the reclamation plan. And I think it's reasonable that the county look at those sorts of issues on a case-by-case basis. And it's reasonable that the county's interests in those areas may change over time. There were a lot fewer people living in Bonner County back in 1981 or wherever it was, and even 2008. So the county's level of interest in these things may change. Now, that said, I think the way even the staff recommendation is written, to some extent, to me, is problematic because it sort of imposes an instant requirement to have a CUP. And that, to me, is problematic. People would need to be given some reasonable amount of time. If you ever were going to impose that requirement, you'd have to give those grandfathered uses some period of time to accomplish that. And it doesn't do that. So that, to me, is an issue. I do think this area needs to be clarified. So this area of the code needs to be clarified. So in general, I'm in favor of doing something that makes sense to do that. I'm not convinced that either one of these proposals, as they're written, satisfies all my issues. I talked about the CUP issue with respect to the applicant's issue or proposal number 3. I know somebody's going to say, well, but it's in the Constitution, but I do not like that last statement. For the complete development of the material resources of the state or any other necessary means to their complete development or any other use necessary to the complete development of the material resources of the state. I think that's vague in and of itself. What is any other use necessary to the complete development of the material? Somebody's going to come along and suggest it's an asphalt plant. And they're going to make that argument. I hate to be that specific, but I'm concerned that that statement is vague and overly broad for what we're trying to do. So I don't think I like either one of the proposals as they're written. But I do think, again, to come back, we should do something to address the lack of clarity about how extraction-based uses are treated, grandfather extraction-based uses.
Yeah, I think that your comments have a lot of merit. I think that we need to ask staff to come back with a staff written amendment to 341. And see what we can do with that when it's properly noticed and some of the issues that Mr. Frankenbauer maybe also in that recommendation. So is there any other motion? Not, I will make a motion. I move to recommend.
I don't think you can, sir.
Okay. Well, somebody makes a motion, please.
Is there more discussion?
Well,
I didn't want to jump right in.
Yeah. Well, it'd be nice if each of us expressed our views on this, because this is no new subject for the county to contend with, what to do with the mineral extraction in the county. And considering, sure, there are conditional use permits that have been issued for new proposals, but there are many, as everybody knows, that have been here for decades. And they're continuing. And a reclamation plan is just that. It's how to reclaim the land after you're done. It doesn't typically get into the other issues of I don't even think they cover hours of operation. That's typically what's in a conditional use permit. Hours of operation and some of the other neighborhood affecting factors adjacent to these. Granted, it's fully recognized by every entity in the state that these are necessary operations on the land if they deal with the material at hand. You don't decide to put one in the middle of somewhere there's no rock or there's no gravel or there's this doesn't work that way. And as was pointed out in the slides, you go down I-90 through Spokane Valley and you're one place adjacent to a gravel pit for quite a ways. It's turning into a lake, but it's anyway. So I agree agree with what Commissioner Pringle has said about the need is there, but I'm not convinced that either one gets there totally for what is needed. I'm still a little confused about the date change. I think I understand the premise of it because it leaves a gap from the way it was stated before. So that one there, if that is whatever the date is, and whatever that use on the ground was, property wise at that date is key. So that might, because they're in the past, that might be a little difficult to absolutely pin it down. I don't know where that leaves us. It might be problematic, it might not. Reiterating the various other codes, again, it's not, I don't know that it helps. We've had this argument time and time again. You put everything in one place, you've got it all at hand. If you have to reference sections, which is exactly what courts do, exactly what law does, it references other sections. So it's not a foreign topic. It is acceptable. At minimum reference, some section in here that would reference Constitution or other state code is commonly the case. Yeah. But this whole thing, I'd have to have a whole lot more evidence in how it could effectively be on the ground continuation on a property, making sure that the impacts are addressed, which again, my experience does not necessarily come through an ideal reclamation plan. So I'm not ready at this point to recommend approval of the text amendment. Welch, you have a comment?
You know, it seems to me that if the fire department was in here and they were saying, hey, let's clean up some language, let's make things easier so we can serve the community, that we would be bending over backwards to work through this and in an effort to serve the whole community. And I would argue that if we looked around at gravel and gravel pits in this county, that this industry and the demand for it is taking care of the community way beyond the fire department. And I think that we're going to trip over words and we're going to get hung up on, well, it implies this or it might mean that. And what we really need is just to find a way to find a happy medium, because there's no scenario here that it's going to be perfect for everybody. We need to do the right thing for the community. And my feeling is whatever, we're going to have to draw a line in the sand somewhere. So let's draw a line. Let's find a happy medium. Let's vote on this thing and let's move forward, because we've got lots of other things to work on, lots of other things to do.
My turn.
Mr. Trident?
I'm really torn now after listening to the three of you. I agree with Josh. I want us to do something. I'm concerned that that our only option is to go with what's been proposed tonight. I agree with Don that there are some things, just a little bit of tweaking, not 2 years worth, Josh, just a little bit of tweaking that could be done to their proposed language. I'm not positive that just going under a reclamation plan is enough. The whole conditional use permit verbiage does not bother me. So I would like to see that possibly addressed.
So,
I'm not completely happy with the verbiage that was submitted, is my bottom line.
So one of the thoughts that occurred to me is that one of the things that we're talking about is, hey, let's push for this conditional use permit. The idea that that that's going to give us more oversight or better regulation, and we're going to keep a closer eye on it. But I don't know that that's going to do anything different than IDL. I mean, let's talk about the staff that we have, and while it's a great idea in theory, do we have the staff to oversee that, to check up on it, to follow up on it? Is that really going to happen? Or is it better left to IDL to take care of that stuff?
Well, unfortunately, it was pointed out to us that IDL has a problem showing up sometimes.
Well,
Which might not have worked for him, but
And
in his favor.
IDL themselves admits that there are
Right.
more local issues that they don't consider in the
Right.
reclamation process.
Yeah.
So, and I would guess that in most cases, the CUP would be fairly automatic, because in most cases, to me, what would trigger a change that's going to impact the community is not digging on different ground than I was last month. It's some significant change in the volume of the business.
Right.
Right. And so there's more traffic and more dust or whatever. And so in most cases, if it's just an operation that's moving along and it's following the normal progression, and they finish mining in one area and they've moved on to another area, you know, I would guess that that's all pretty routine, and I don't see that there would be typically any onerous conditions imposed. But it gives the community the opportunity to review a specific use that, I mean, think about the whole purpose of a conditional use permit. It's to deal with uses where we can't say, no matter what the nature of that use may be, it's compatible with this particular zone. So we want to look at the specific scope of the use and have an opportunity to think about whether some conditions might be required in order to make it compatible with that particular zone. That's I think the purpose of the CUP. And I think that fits for this case. I think there's some details that have to be worked out, because I don't think you can impose it immediately. There's the whole question of what constitutes an expansion that would have to be addressed. I don't think that's been clearly defined. You know, the one more shovelful is a compelling argument to me. It doesn't work that way. But I don't know, maybe that can't be, maybe there's no solution to that problem. I don't know, but I think it's reasonable to have a CUP. Sure, you could have unreasonable conditions, but I don't think we would in general.
But if, I mean, I think what I hear you saying is that a CUP wouldn't be a difficult thing to get. And if it's not going to be a difficult thing to get, then why do we need to get it at all? Right? Like,
no, there's difference.
I mean,
He's talking procedure.
Yeah.
Procedurally,
Right.
it shouldn't be a difficult thing to do. It's just getting it on the schedule, figuring out what conditions
Right.
shall be imposed, if any. But no, it's not, well, if it's that simple, then. A new property comes in, we want to establish a mineral extraction. Okay, here's the things that are looked at under a conditional use permit.
yeah,
You're
but
gonna
just
end
to,
up with various things.
just to clarify, I thought we were talking about those that are referenced here as grandfather potentially.
Yes,
not
correct.
new
Yeah.
ones. New ones would be
Okay,
new ones would
but
be absolute.
we're talking about having a conditional use permit in the process, that if you're going to physically or in other ways expand your use, change your use, increase your use, get the right word, then is it warranted to look at it in the same way for that new use as it would be a brand new property brought into that realm? I think there's merit to that. It should be, everything being equal. If something's been in use for years, it's ongoing, it's recognized, it's there. And any neighborhood can tell you stories about these places. But what is the county's responsibility towards the public in dealing with any form of use? just any use is subject to the code. And if it's not being operated or used in correct way with the code, that could amount to a violation. And regardless of staff and everything else, that's still, could end up as a violation of code. So that's a different realm as part of this, but it's a different aspect of it. So also I think we're concluding that we don't really have the latitude in this case to amend either what the applicant has proposed with the staff proposal or come up with one ourselves. This reminds me very much of the previous code amendment that was proposed by Keep Bonner County Rural. And in that case, we asked the applicant if they would be amenable to a workshop to better craft the language. And I think we got there with that. So I feel somewhat compelled to offer the same to this group with, are you absolutely set on what's being proposed, or did you see the benefit of some of these discussions to work out better language and continue to look for a solution to the problem?
Can I ask you guys, can I highlight what to me is like the legal gravamen, like the inflection point, and ask you guys maybe to deliberate on that if I can kind of explain it to you. The way I see what the case hinges on is I think you guys are dancing around it, but you might not have hit it right on the head from my perspective. All right, so if I could distill this down to what I perceive it as, it is whether or not, first of all, we're fighting against uncertainty because the doctrine of diminishing assets hasn't even been addressed in Idaho, and I agree with Toby on that. So we're being asked now to decide essentially whether or not we want to recognize it or we don't. And where the rubber hits the road for that in this case is if we're going to recognize the doctrine of diminishing assets as it relates only to gravel pits because they are kind of unique. I think that would suggest that the county's right to impose a conditional use permit on a prior existing gravel pit would be inappropriate. And this requires us also to get down to brass tacks as to what you consider expansion to mean. The reason there's many different persuasive authorities, Washington being one, that has recognized that doctrine. Other states have gone the other way and said, we're not going to recognize it for a lot of the reasons that the planning staff has brought up, that and it's kind of rooted in this almost philosophical notion of what does it mean to expand? Are we going to look at the physical footprint, the one shovel load? Some jurisdictions have said that's what we're going to do. Others have said we're actually going to look at the use itself. That's what's being advocated here by Toby and Jeremy and their clients. So if a prior non-conforming gravel pit took 1,000 yards of material out of the ground in 2007, and then they did the same thing the next year and the next year after the law changed, is that considered expansion? Well, reasonable minds can disagree on that. There's a lot of persuasive authority in the state of Idaho, and they've quoted it, the deference to mining in our constitution, statutes, comp plan, that may suggest, that could hint that the Supreme Court might actually adopt the diminishing asset doctrine if it was presented to it. But that's just guesswork. We don't know. The reason that I try to be, not to advocate for a personal direction on this. When I looked at staff's recommendations and the requirement to, or the suggestion that there would be a CUP, I found that to be not prohibited by the law because we haven't adopted that diminishing asset doctrine. The applicants here are essentially asking you to recognize that. So if you could, maybe go into that a little bit, see if you think, comment on whether or not you think that's appropriate for this particular use. and what your version or your vision of expansion is. Because to me, how you come out on this issue starts there. Because if you believe that expansion just means the expansion of the use itself, we're going to take more material out of the ground, then it then kind of suggests that just continuing on in the manner that was done before the law changed is not an expansion and therefore doesn't require a conditional use permit. You could also come down on the other side and say, no, that looks like expansion to me and therefore subject to regulation. And I agree. I don't think that's been preempted. I think there is room for the county to work alongside state agencies if we take that position. So I don't know if I think you guys are dancing around that issue, but I'd like it if you guys could maybe give your thoughts for the record, and hopefully, because that's going to weigh into the recommendation and what the Board of Commissioners will eventually look at. If you could give your opinion on how that principle looks to you.
Bill, could I just clarify one point in this discussion? And that is the recommendation wasn't for the next shovelful, right? The recommendation was for the existing reclamation plan that's currently in place. It wasn't to say they're automatically, they have to stop right now today. The recommendation was that we look at the reclamation plan that was in place. When they're going to go back to IDL and expand that reclamation plan, that means they're going to make the pit larger based on that reclamation plan. So expanding that reclamation plan. So yeah, I just wanted to clarify that. It disturbed me that we were thinking about the next shovelful because we're not.
That wasn't clear to me. So maybe I need to go back and reread what we decided, but
Yeah, that's the whole point. Yeah, that was the whole point. Yeah.
Yeah, that's the way I interpret it, going back and looking at the language that is here. I can see why that may not be clear, but I certainly interpret it as physical boundaries of the existing use, not taking up the shovel. I don't think it really does deal with the diminishing returns type of thing, but maybe it does. But the way I looked at it is IDL approves a reclamation plan, and that is for specific acreage. If there's an expansion beyond that, as I understand it, that requires a new reclamation plan or some different one. So applying this to the boundaries, as Milton said, is consistent with what the reclamation plan would do. So that's how it's going to trigger a conditional use permit when you actually expand the acreage that you're using. And maybe we need to clarify that in a staff prepared code amendment. It seems to me that we're, based on what you said earlier, Bill, is that we're hogtied by the language that they proposed, which is to me unacceptable. I mean, it's just unacceptable. I don't think we necessarily have to get into the area of diminishing returns. We're just talking about a boundary, not the next shovel of dirt, or next shovel of gravel. It's not doing. I think that would be problematic if that's what was interpreted by these amendments and the staff recommendation. It seems to me we have an up or down vote.
And it would seem also, based on those comments, Wilson, the doctrine of diminishing returns specifically deals with non-renewable resources.
It's directly targeted at that.
Directly mineral extraction.
It's a unique non-conforming use.
Right.
It's not like a shingle mill plant or some of the other old ones we've done and that's gone through the CUP process. It is an outlier in the non-conforming use.
Yeah, specific to non-conforming use, but I think you can also make the argument that the diminishing returns doctrine applies to a brand new site. If this is the same stuff.
I think it's
just that
I think it's it's directly targeted at the non-conforming. Because, and it goes to, again, how you choose to define expansion. Because we're not talking, I'm setting aside the reclamation issue. I'm saying, we're just talking strictly about how we define non-conforming and what it means to expand a non-conforming use. What does that look like? And what triggers that for us? That's where you see the split of authority in those jurisdictions and how they define that. And the applicants here are advocating for the fact that they're focusing on the use and the continuing operation as opposed to the focus on the physical footprint. But reasonable minds can disagree. We are in kind of an unknown, uncharted area because of this. I can't believe that this hasn't been addressed.
It doesn't.
In the state of Idaho, given the prevalence of mining and things, that's a big deal here. But we don't have the guidance from the Supreme Court telling us how to answer that question. So without that, you might say that we have the latitude to go either direction, but I can't guarantee that that would be upheld. Courts might choose to adopt that doctrine, and that could radically change the county's ability to require a conditional use permit for something that was a prior non-conforming use. If those old mines are granted the benefits of the diminishing asset doctrine, the court could say that requiring a conditional use permit is impermissible. I don't know how that would go.
And you would apply that even to boundaries?
Well, boundaries of the property itself.
No, boundaries of what has been used, not
right. That's
shovelful.
Right. But I think I don't know if we're arguing in circles here, but again, that's expanding the physical footprint. If that's what you're talking about. That is what the diminishing asset doctrine is driving at. Does that constitute expansion? The diminishing asset doctrine says no. It says that it focuses on use and not on just mine growing. I hope I answered that question. But that's
but that same doctrine gets into other. I'm thinking of, okay, somebody goes in and they make a claim on property because they're going to go hard rock mine. So they do picks and shovels and they get a little track and a dump cart. And they make a big slag pile and they take out ore and they send it away. But it costs too much to send it away. So now we're going to have a stamping mill right there on site. One of those great big things that you see out in Silver Valley. The whole valley shakes when those things start stamping. Is that an expansion?
all right. So that goes to Commissioner Frankenbach's consideration.
What's necessary to
does it mean if you're mining gravel, does that mean you only get to keep mining gravel, or do you get to then do associated industries on site?
Exactly.
I don't know the answer to that question.
See, that's part of it that isn't necessarily covered in this text amendment.
I don't know if that's I think it gets away from the literature that I've read on the diminishing asset stuff. I've only looked at it in the context of continuing the same activity.
Same activity, right? It does talk about in the state code or in the Constitution. It does talk about whatever means is necessary to complete your excavation.
And a court might act, and a court could say, I mean, like this could be the canary in the coal mine. Thank you.
Canary in the quarry.
Canary in the court. Yeah.
A court could adopt that argument. There are we've heard pretty compelling arguments as to why that's appropriate for this unique kind of industry. It may do that. We just have no idea.
Okay. So I want to try to answer your questions, I guess. I think from my perspective, the grandfathered uses should absolutely be enabled to fully extract the material on their property. But I also think there's room for the county to impose some reasonable conditions on expansion. Now, what is expansion? I don't know. The extent of the current active mine, that doesn't work for me. The extent of the current reclamation plan, maybe.
That's a piece of it.
Yeah. As I sat here thinking about it, and I didn't think about this before I walked into the room tonight, but to me, it's probably more important to understand the volume of material that's being taken out over a given period of time, because that's probably what really affects the
That
neighborhood.
focuses on big use.
But I also immediately recognize that there's all kinds of practicalities with trying to do that. I'm sure there's seasonal variations and one year to the next. One year we got a big project going on in 95, and the next 3 years we don't. So I'm not really, I like the idea conceptually, but I'm not really sure how you would mechanize something like that practically. Yeah.
And it's not that we haven't taken a shot at this over the last 5 years. I mean, there's been any number of plots and some almost made it to proposals in code change to get to this issue. So. Okay.
Mr. Wood wants to make a comment.
Well,
Public hearing has been closed.
Yeah, we can't. Yeah.
So let's do something here.
I like the idea of some kind of a workshop to try and work through some of this, answer some of these questions, get some definitions with some of these.
I think it's the possibility of working out some language. I don't know that we can get there. I'm not feeling the same sense of, okay, let's talk as we did with the other land use code change that we did a couple workshops on. I don't know if that's right or wrong, but I didn't get any sense of response from the applicants on that motion of that.
Well, it seems to me that whether that's a good idea or a bad idea, right here today, tonight, we're faced with an up or down vote on the applicant's language. So let's do that.
10 days. You have 10 days to make a recommendation. Maybe it's 30.
It's 30, right? So that's, I'm thinking, when we worked that out with the Keep Bonner County Rural Group, we did end up with workshops.
Yeah, there was a different situation there.
Really? Code is code.
No, the application was withdrawn.
Well, that was how that was in. So I'm saying that's how, that's,
Sort of. Well,
that's
sort of.
how this would have to work out.
I think the applicants in that case wanted to have.
They were willing to do
workshops.
that, yes.
They wanted to cooperate and do that. In
Yeah.
this case, the applicants that had.
Well, that's what I'm
asked.
sensing. That's what I'm sensing. No, there's no desire to do that on the part of the applicants. I mean, they can amend their own application, which would essentially it's either withdraw the one that's present or just amend it.
Well, like Bill, could they offer a split recommendation? The first part.
1, 2,
versus the
3,
second part?
1 yes, 2 no, 3 no, whatever. I don't.
Yeah.
As long as you're keeping with
Do they-
with the original language, I mean, it's really up to the applicants.
Does that create internally consistent code if we do that? Yeah, I think you'd have to look. at
I'm
that.
just throwing out.
Yeah.
I know that.
I would suggest for clarity's sake, that,
Oh,
and especially because the applicants have, although I think Toby did mention he's okay with
Yeah,
the
number 1 and
wiggle room and on 3 first thing.
but
I would
not
just,
2.
I would give it I would go
Up or
up or down.
Yeah.
If I were
think
on
it's
in your shoes.
warranted that way.
I think that's the choice we have.
Yeah.
So let's just go either up or down and somebody make a motion and decide whether that motion is going to be approved. Unless, nope, you have any other.
Words of wisdom. Thanks a lot. You better just keep yourself.
All right.
You're a guy, you know?
Commissioner Frankenbach, I'd like to make a motion. I move to recommend denial of this project file AM 004-22 to the Board of County Commissioners to amend the sections of Title 12 Bonner County Revised Code as presented or amended in this hearing based upon the following conclusions. And I think it fails to meet the objectives of conclusion 3. I think something about fails to meet the objectives of the comprehensive plan. The decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to adopt the findings of fact and conclusions of law as set forth in the staff report or as amended during this hearing, and direct planning staff to draft written findings and conclusions to reflect this motion, have the chairman sign and transmit to all interested parties. This action does not result in taking the private property.
Is there a second?
Commissioner Davis, I'll second that motion.
Mr. Davis seconds the motion. All those in favor?
Aye.
Aye.
I,
Commissioner Pilch votes nay. All right, that's the end of that item. We'll take a little break while everybody kind of clears the room. I don't know if we have any discussion.
Yep. Oh, yeah. We got another.
Oh, yeah.
5-minute break.
Yes. How much longer are we gonna stay?
Don, what do we got? About 30 minutes?
process.
We're gonna go real quick.
Right,
So-
stop shouting at me.
Got something, Don has something. Don and I, we met what was it, Friday.
That's expert day. We can't talk about it.
No.
I'm just kidding. I'm just kidding. Stop.
Specifically not.
And so we kind of went over
Didn't
some.
have a quorum.
No. I just was talking to Bill. So, no. Thanks, you guys.
Okay.
Bye.
Yep.
So we set some hard dates for.
Yeah, we put
workshop.
together a schedule to complete the plans, goals and policies of the comprehensive plan. Yep,
2 weeks ago.
yep, 2 weeks ago. Yep.
Don
And
I-
so we put it on the agenda to talk about it and maybe even consider voting on how we want to proceed. So you guys can't meet on the side and change your mind. We want commitment, the willingness to pay the price demanded.
We did commit.
Sorry.
We
Sound like my
committed to.
I thought so, but apparently they had a meeting. Go ahead.
No.
No. We
Yes,
just went
Ellen.
over the dates. All we did was just, we said, where's the calendar? Yes, that date in, where are we, in July, the 5th and the 19th are gonna be workshops. Is
Yep.
that what you came out with?
Yep, that's right.
That's right.
Duplication of service. No problem.
So,
So
so the first task that we have is to review the components. So we each broke those up, we've got
Okay.
at least two
Yep.
components.
Yep.
So a little quiz right now. How's everybody doing? Looking at their components and the goals that came out of those?
Been doing
I'm doing fine.
Been doing a lot of reading.
They're right
I had
here.
a little trouble with.
You got the
I had to
easy
read
ones.
this Linscott thing 3 times, so I'm a little behind
What
on
what
my
I,
recreation
what I would like to
assignment.
see. is-
But I can move forward easily.
I don't know how formalized you want this, Milton.
Huh?
One of the ways that I could put out what I've done is if I had a Word version. of goals and policies.
we're gonna get
They're
that.
on?
It's coming. I was gonna do it this afternoon, but we spent 2 hours working on the fee schedule.
They're all out there.
They're on this, on the shared drive.
There they are, but I was gonna compose it into a
It's not
template.
It's not a Word document. is it?
Yeah, it's under implementation.
I thought it was a PDF.
No,
No, there's another,
Why do you put
there's
that
another
on?
folder that
Why-
says
why-
Word
3
documents.
months ago, at our request, so we could work it.
Yeah, it's under implementation.
If we knew how to do that.
I don't know.
So, but we are gonna put it together in a template that says proposed comprehensive plan.
So here's the other thing I
Buckets.
thought up over the weekend. That I want us to start looking at sub-area comp plans. Have we had judicial review on any of that?
Okay, so no, it has not gone to court. We have not had judicial review on that.
We don't have that.
No, it's not gone to court and it's not going to go to court. So what we asked everybody to do 2 weeks ago was to review the component that you're assigned to and then review the sub-area plans, looking at the goals and policies that may relate to the component that you're assigned to. So if you're assigned to natural resources, you would read the component in the comprehensive plan under natural resources. Then you would read the goals and policies for that. Then you would look at the sub-area plans where they talked about natural resources and goals and policies. And then you would, as you review the current list of goals and policies, the first thing that I would do is I would read through those goals and policies and scratch out the ones that do not apply to land use. Right? Like every property should have a windmill. That's not right. Right. So we scratch out some of the things that don't make sense, right? That don't apply to land use. Then you would propose goals based on what you've read. That what we're trying to do is create goals and policies that are in line with the current comprehensive plan and the sub-area plans. And then the ultimate goal is by the end of August, we would have this template put together into a draft of a comprehensive plan of goals and policies. And understand that's what we're working on, is just that. And we would take that, we would make a recommendation on that to the board to update those goals and policies so they coincide better with those components. And then after that's done, then we'll go back and review some of the other components that we're urgent and pressing on. We'll spend the time that needs to be done to update maps.
And ultimately update the land use map, the comprehensive land use map. But if we do that, I'm afraid that if we don't address this now, we're missing the opportunity from the sub-area plans. We're missing all of that input that we received from those 60 plus individuals who spent thankless hours putting that together. We're going to miss the opportunity that those bring. And then we're going to continue with this hey, every day we have people come in our office asking, can I change the zoning on my property? Every day somebody comes in and asks us that question. And many, many times we tell them that if you were to change the zoning, you also have to change the comp plan map. We have got to get goals and policies in place that we can lock this stuff down or make good decisions, help us make good decisions. So we don't end up with, an area that's completely green with the blue spot in the middle of it, which there are those out there. Okay. Up Rapid Lightning Road. That's right. Those are puns. But the other challenge that we're having is we continue to have people come in and want to do commercial development, but the land that's for sale is not commercially zoned. There's just not enough of it in this county. And so there's other things that need to be identified as we go through this process. But it's the goals and policies that are currently right now creating the most heartburn in our review of documents, not only for zone changes, but also for conditional use permits. So, sorry, did I talk too much?
No,
That was beautiful, really beautiful.
So it's those
On
things
record.
there. In addition, a lot of people are now pointing out, when they're reviewing a file,
Yeah.
they're saying, okay, the goals and policies say this, but the text over here says this. And there's
Yep.
no goal that comes,
Yep.
there's no parallel. So they're
That's
going all the way
exactly
back
right.
into the text and finding things that apparently were stated, was forced to say it should be this way, and there's no goal. So they're saying, go back to the text. That means we got to review the text as well.
So, and that's what's interesting. So what's Idaho Conservation League? They said that one of the concerns they had was that that exact thing is we didn't review the comprehensive plan, and because when it talks about Trestle Creek, it actually talks about Trestle Creek in natural resources, but there are no goals about Trestle Creek in natural resource section.
Text talks about it as
Yep.
something. So that's true. So I mean, it's a quandary because I can't look at the goals without reading the text, because I want to see that those are valid. One, that they came from the text. And we do have
Right.
some goals that just magically appear.
Yes.
Because they're not talked about in
Yep.
the text. So
Yep,
what's-
they seem
what's
pretty
that all
random.
about?
Yep.
But the staff has pretty persistently gone to the goals, the implementation component as we see it. Let's say, here's what the comp plan says, without going back and searching, doing a word search to see that the text in some component says something about railroad ties or,
I'm looking at
It's
the
really
text.
tough.
I don't know, maybe that was beyond what the assignment was.
It kind of
but
got thrown in at the end of our discussion.
I'm
2 weeks
trying
ago.
to excerpt, I guess, some key points.
Yes.
from the text.
Yes, absolutely.
Right.
Yeah, because that's what we're trying to do is make these goals and policies be more in line with the text of the
If they
comprehensive
are, if
plan.
they're absolutely in line, then you can forget about the text really, because it's absolutely covered in a goal or policy. And that's what it should be.
I probably thought that was the assignment.
Yeah, that's-
We're
yeah.
going to look at the sub-area plans. We're going to check those for any information that they have, go back to the text, and then, deal with
Right.
those policies.
Yep. That's
So
right.
Swati and Chad put together a spreadsheet that outlines the 5 area plans and does a subject comparison. Here's a subject, here's how they each talked about it, whether they were the same, whether they differed, or some of them were silent on that. So that's a good resource anyway. That's in the shared files.
It is?
Yep.
Okay.
And
Good to know.
the other one about looking at the goals to do that first level test. Is this a land use regulation or action or not? And that was done too. That was a year ago or more. So that's in the shared files as well. which was a great exercise. I'm trying now to figure out something. We'll have to discuss this. Most of those goals that are not land use regulation are good goals, but where do they belong? How do we find a home for them? They're more like social goals or community goals or something. They're valid, even the ones that say Bonner County shall. Well, that's got nothing to do with the land use regulation. Some of them just aren't going to show up in Title 12. But I don't want to ignore those because those came out of public review.
Not to be
So
too
that's
picky, but is it really land use regulation or is it land use?
Well, the
'Cause I
code
think-
says.
I think the code says land use, doesn't it?
No, it says here, these are your
So this is
components
my
that you will,
confusion.
as they
Are you
relate
going
to
to
land use
share?
regulation or action.
Or
Goals and
action.
Objectives,
Or action.
Word,
Action.
PDF.
I know. Well, what is a land
No,
use
those
action?
are inconsistent.
Deciding whether to vacate a section of public road.
Right?
That's a land use
A
action.
land use action is what we dealt with
Where do you-
tonight.
where do you see
But it's
that?
not,
complex.
but it's not
That's a
land,
land
use.
use
But it's
action.
not land use regulation. In other words, my argument would be there are many things that the Board of County Commissioners do that I would say are land use action.
I'm gonna
But
let
are
you
not
figure
land
this
use
out. You
regulation.
just show me when we
So,
get home.
so somehow we
Okay.
have to ferret out the
You
ones
know,
that are.
They
related to
decide
land
to,
use
they're gonna
action.
buy land to put in a county park.
Yep.
That's land use
That's a
action.
land
It's
use
not
action.
land use regulation.
And somehow guidance is going to come from the comp plan for
Right.
those actions.
Right.
Clear as mud?
We've got county property that's supposed to become a park. But it's not.
Supposed to become a part?
Oh, it's 40 acres to hunt on.
Yeah.
County hunting ground, right?
Yeah, sure.
County hunting.
That's FEMA property. Culver Road.
Oh, yeah.
Beautiful
about
piece
that.
of property.
Okay, so if we're on track, so the other one, you suggested that we send our results to you.
Yep,
Okay.
at Al.
Huh?
You probably want to include Jake or May and Swati.
Well, that's what I was going to
Yeah.
ask.
Yep,
How long are you receiving emails?
till June 3rd,
Okay.
probably. So yeah, this will be my last meeting here with you guys.
Maybe we ask.
I'm gonna go do this for a different set of angry people.
For another county.
I don't know if you can top a few of the ones that were here tonight.
Maybe we ask where.
All right, no,
Okay.
later.
We'll find out.
Yeah, he will.
Okay. That's
I don't know.
immaterial to the conversation. But no, if we send them in, and we need to work on our stuff and get it in
So this one
and
right
send
here,
it.
shared with me.
There's another document on the shared files. I think it's still there. That was my duties annotated. Is that still on the shared drive?
I think.
Yeah, I think.
2 years ago, I went through the whole blooming thing and just every component, reading through the component, and I had comments and thoughts. And then I went through the goals and so forth and thoughts on those. And I dated them, but I've just put in a bunch of them. And I haven't updated that file on the drive yet.
What was it called? Do you remember?
Duties annotated
Duties of who?
of the planning commission by state code. That's the other thing. If you haven't read 65, Title 65, read it.
Oh, yeah,
I've read chapter 65.
Yep.
Title 67, chapter 65.
So
In its
pretty
entirety.
outdated.
It is, but it is what it is.
That's 6508.
Well, all of it. 6508, 9, 12, 11, 13.
If there was a well-organized APA group in this state, they
Yeah,
might
if there
propose
was.
an amendment,
If there was,
right?
if there was,
Yeah, I get it.
all it is party. Have a convention in Boise and party. That's APA, Idaho.
Yeah. Right.
It don't work. It broke. All right. What else?
So we're good with the schedule then?
Yeah, I was just sorry I wasn't here, but I was not feeling very well.
No, we got you covered, Brian.
Yep.
Okay.
That it?
So
I think
for
so.
you, where's your hazardous stuff, all the stuff from Bob Howard's? Is it in the shared drive?
Yeah,
too?
should be there.
Yeah, it's on there.
It's not complete because I lost stuff with the virus.
Yeah.
Allegedly.
Oh, no, it's,
Oh,
we've been offline on Energa for a week. It's not been pretty. Yeah,
Paper and pencil down there?
pretty close.
No, they shredded it.
Yeah.
There was something else.
I don't have my note sheet. I
Oh,
didn't bring it.
geez, we
I
came
know.
across, there was like 1 or 2 chapters in there that we really don't use.
Oh, yeah.
Community design.
It's
Well,
not even listed in our comp plan.
well, except there's this batch of goals and policies. So what happened, I think what happened is when the state came out with that, adding that to Lupa, I think they decided to add it. That's the only thing I can come up with.
Because it's not. you know,
Yeah, there's not a
components.
section of it.
It's not-
Yeah.
It's not there.
Right. They didn't go hire JUB to do a component for it.
So the other one, because there were, I think, over time, there were 3 components added. That one, community design, the electrical system.
And
lines,
airports.
And airports.
Yeah.
Electrical system, I think, I forget who it was, some previous planner checked that out and no, it has no present bearing. Airports, though, does. It talks about any public use airport in the county jurisdiction.
They're in
So-
cities, aren't they?
Yeah, I thought we talked about this and determined that the public airports currently are in the cities.
That's true. But Toothman Norton was hired to put together a guide for that component specifically. And it says regardless of where it is, if there's county land in the influence zone of that airport, the comp plan shall do it, shall.
Plans, maps and ordinances that, I don't even know. I'll have to look for it.
So I just.
So
I
we,
just passed that document, that guide on to Swati the other day.
okay.
And it pretty much says we shall. So,
Except for the head of Lupa or the head of the thing says, if you're going to leave one out, say why.
right, so say why.
Yeah, because all the airports in the cities.
It's pretty simple. You gotta read the document.
We'll see if we can find the document you're talking about.
No, not find it, you've got it. I got it right here in my pocket. As a matter of fact.
Okay, just leave it there. I don't need that.
Possible effect
What's that?
would our
Another
comp
time.
plan have on the waste sampling?
Well,
Got a long drive,
Well,
It's the other
hour
way
and a
around.
half now.
What impact does the airport have
You-
on county property?
Yeah,
beyond
we do.
the city limits?
Okay,
Well,
and you live way up there.
Noise,
Reel it in.
light, glare, hours of operation, all
I'm-
those things.
I'm done.
Bringing the airport up to compliance.
Yes, yeah.
That's supposed to happen.
I got an idea. Why don't we give Don the airport?
There you
I've
go.
already taken it, kind of, sort of. And I
There you go.
I am trying to get a hold of the person who is in charge of dealing with local entities at ITD Aero. I've been calling her number for the past week and a half. All I get is a busy signal, not a busy signal, but I'm not here, leave a message. And I've
Maybe
left
we're talking to
countless
Dave
messages.
Shuck too.
And talk with Dave Shuck.
Yep.
I've got to do that. So I will do that this week.
Anything else imperative? Alan and I have an hour and a half long drive.
All right, so this meeting continued till July 7th. will be the
June.
third-
Oh, no,
June.
June 7th.
June 7th. Good.